Calling to order the April 15th, 2024 meeting of the East Amwell Planning Board. Let's stand for the flag salute.
Flag of the United States of America, and to the republic for which it stands, one nation, under God, with liberty and justice for all. I learned it before 1956.
Kristen.
In compliance with the Open Public Meetings Act, this is a regularly scheduled meeting pursuant to the resolution adopted on January 16th, 2024, with a meeting notice sent to the Hunterdon County Democrat on January 18th, 2024. A copy of the agenda for this meeting was posted to the Township website on April 11th, 2024, posted on the bulletin board, and filed in the clerk's office on April 11th, 2024. Miss Emily Deadweiler.
Here.
Mr. Matthew Kohat.
Here.
Mr. Dante DePiero.
Here.
Mr. Jamal Kadri.
Here.
Mr. Al Nardi.
Here.
Mr. Richard Catanacci.
Here.
Miss Mary Van Horn. Miss Candace Wiggum.
Here.
Mr. Michael McGovern.
Here.
Miss Maria Teresi.
Here.
Attorney Alexis Smith.
Here.
Engineer Robert O'Brien.
Here.
And Planner John Burry.
Here.
And
We
Kristen
got
Pat.
everyone we need.
Thank you.
First up is the review of the agenda. One minor change is that we will not be voting on we will not be approving the special meeting minutes from February 11th, 2024. They'll just be held to the next meeting. They're almost done. And I think that was it at this point. In case anyone didn't notice, there was an earlier version of the agenda that did not have the resolution for approval from last month. That's been added to the agenda, but I don't believe that I think that's, everything out back there is accurate. So I think that's where we go. First, next steps. Welcome.
Okay. How do you say your last name? Teresi. Teresi. Okay. Smith Teresi, can you please raise your right hand and just repeat after me? I, Maria Teresi, do solemnly swear
I, Maria Teresi, do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
that I will bear true faith and allegiance to the same
and I will bear true faith and allegiance to the same
and to the governments established in the United States
and to the governments established in the United States
and in this state
and in this state
under the authority of the people,
under the authority of the people,
and I will faithfully, impartially, and justly perform
and I will faithfully, impartially, and justly perform
all duties of the office of a member of the planning board,
all
alternate to
the duties of the office of a member of the planning board,
alternate to according to the best of my ability.
according to the best of my abilities. So help me
Thank
God.
you. Thank you.
Welcome, Maria.
Sign that, and
Sure.
I'll take it over to Kristen.
Okay, thank you.
Citizens privileged to speak on items not on the agenda. May I have a motion to open to the public?
So moved.
Second?
Second.
All in favor?
Aye.
Open to the public for items not on the agenda. Going once, going twice, not going to wait long. Closed? Closed to the public. Do I have to motion that back? I don't think so, no. Okay, next up, presentation of minutes. As I mentioned, we're not going to be approving the February 11th, 2024 meeting minutes, so just March 18th, 2024 regular meeting minutes. May I have a motion to approve?
I so move.
Second?
Second.
All in favor? You can vote.
I cannot yet, Mr. President.
Aye.
Aye. Okay. Okay. Next up, resolution for approval. This is the resolution for approval when from the lighting ordinance consistency review. even though it doesn't say lighting anywhere in there. A resolution of the East Amwell Township Planning Board confirming master plan consistency of ordinance number 24-4. So those of you who were here to vote on this, may I have a motion?
I so move. I do have one point before we end up voting, but I do move.
Okay, can I have a second?
Second.
Okay, you can be heard.
So I saw one thing that I believe is a typo, where the, in the resolution it said near the end that Township Committee made no changes prior to adoption. I think what was intended was no changes before introduction, because
Okay.
it hasn't been adopted.
Okay,
It's the status currently with the Township Committee is that it has been introduced, and
Okay.
that's why this body is being asked to
Okay.
comment on consistency.
good
So
catch.
just that one change.
Thank you.
With that amendment. I
So
would move
Kristen,
with
can
that
you
amendment.
make that change? And with that amendment, may I have, let's see, we already have a second. All in favor?
Aye.
Took me off my rhythm.
Sorry about that.
No,
Sorry, Ms. Chair.
I am totally teasing you. I'm good. I'm totally good. Okay, next up. This is a continuation of the hearing. Craig Mattis and Janine Mattis.
Good
Hi
evening,
again.
Madam Chair. Good evening, members of the board.
Good evening.
Kara Kaczynski, McNally, Yaros, Kaczynski, and Lime, here tonight to hopefully not take up too much of your time and finish the application that was previously before you. This application is for Craig and Janine Mattis, 1217 Old York Road, Block 8.02, Lot 26. And what we're here before you tonight for approval of is a minor subdivision with now 2 variances. So just to kind of recap where we left last time, Mr. Mattis testified, we answered a number of the questions in your board professionals' reports, and then we were sent home with a little bit of homework. The lot line originally was very irregular, and it was drawn because we were attempting to make sure that not only did we try to minimize the variances, make sure that we had the proper lot sizes in each zone, but also to make sure that the structures that needed to be on each property were appropriately placed. Since then, we've gone back to the drawing board, we've made the change that you see before you, and I have our engineer here tonight that's going to explain to you exactly what we did. I want to let you know that in doing this, one of the things, obviously to also address your concerns, but we will need to enter into some easements with the adjacent property owners. So just for as long as he owns that property, he can have access to the structures on the other property. So again, to mitigate and make the lot lines better, this was something we needed to do in order for both property owners to continue to work together and be able to use the structures that are in their, that they've been using up until this point. The plan is that that will not continue going forward, but I just want to let you know. So we did a lot of work to get you hopefully to where you need to be.
And you'll take us through that.
Absolutely, yep. So if I could, I'd just like to recall Mr. Mattis, just to put something on the record with regard to the subdivision plan that we have here.
Ms. Kaczynski, just before we get started, so I don't mess up your flow, can I just swear everybody in, we'll let the record reflect that Mr. Mattis was previously sworn at last month's meeting. Mr. Mattis, you recognize that you're still under oath?
I do.
Okay, thank you. So may the board's professionals as well as the applicant's engineer please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Ms. Kaczynski.
Thank you very much. So Mr. Mattis, as you indicated, you know you're still under oath, and I just wanted to put on the record for the board, we went back to the drawing board after the last meeting and worked with your engineer to create a new subdivision plan. Is that correct?
Correct.
And that is a copy of this plan that's up on the easel here.
That is the proposed plan, yes.
So can we mark that as A1, and then
A1.
I'll get the specifics into the engineer. But the only thing I just want the board to know is that you are willing to abide by this new plan, and you're satisfied with it, and it does exactly what it is that you and the other property owner need in order to move forward.
Yes, that is correct.
I don't have any other questions. I just wanted to put that on the record for you.
Kristen, did you end up making copies for members of the planning board of that new map?
Well, this will be the official board
That will
copy.
be the official, but were there?
This won't leave
Okay.
if you want.
I'm
to
sorry, I
respect-
can't hear you.
This exhibit will be the official board copy. This exhibit would be the official board copy. If you would like to come and inspect it in our office, it is open for inspection at our office, but we also have it on the drive. We do not have individual maps, colorized maps for
When did we
everyone,
get
though.
it?
We have it on the internet. You can also come to the office and inspect it.
When?
Oh, during our office hours. I have office hours Monday and Wednesday between 10 a.m. and 3 p.m.
Date?
You're asking
Oh.
when we received this map.
Yes, when did we get the map?
We're receiving it right now.
We're introducing this as an exhibit to the board tonight. And I did
You're
actually,
seeing it for the first time. That's what-
Yes.
Yeah.
I did actually make copies, or made a copy. I didn't think you could really read it very well, which is why I didn't bring them for everybody, but I'm happy if anybody wants to take a look at it up close.
Thank you.
Hopefully you've got better eyes than I do. Okay, so
Kristen,
I
is
don't
it possible just to get a copy of that for each board member? Oh. For mine.
It was on the.
Can I clarify, we all have access to a copy of
from-
this?
Yeah.
the board
Electronically,
members-
in our
This
files,
is in our
yes.
files, yeah.
Yes.
Yeah, so.
Electronically,
Yes,
yes.
yeah, we all
Yes,
have this.
We all have this.
That's it in color. You can't see it in color, so I did it.
Okay.
So
You
I
may
don't have
proceed.
any other questions of Mr. Mattis. I don't know if the board does, if we want to reopen it up to the public, but I just wanted, just on that one issue, I just wanted to put on the record that he is satisfied with this new plan and willing to abide by it.
You can open up to the public just for Mr. comments on his testimony
Okay.
and then close and then
Okay. May I have a motion to open to the public, just for,
Yep.
second?
Second.
All in favor?
Aye.
Open to the public for questions specifically from Mr. Mattis. Rick will, come forward, please.
And it, just on his testimony tonight?
Yes, just on his testimony.
Just on what was just provided.
Do we want to provide that
The
mic?
microphone? Yeah.
That'd be
Oh, is that on?
You can all hear me, but it's lovely in front of a
For the
mic.
rest of the night.
Yeah, only-
Yeah.
is that
It's good for
on?
you too.
Maybe on our special microphone stand there.
All right,
Thank you,
Yeah,
Rick.
it's,
thank you. One question.
Can you state your name?
Oh, sorry. Rick Wolf, 21 Rynearson Road here in East Amwell Township.
And Mr. Wolf, can I just swear you in?
Yes,
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Mr. Wolf.
One question. Under this new configuration, what are the relative lot sizes?
So our surveyor will provide that testimony, but I'll tell you that they are 10.52 and 2.01 respectively.
Thank you.
No problem. He'll go into great detail on that.
Anyone else? Okay, seeing no one else, closing to the public. We call your next witness.
Thank you. I'd like to call Mr. Antonin Hajar. Unless you may want to stand. All right, Mr. Hajar, you've been sworn. Let's put your qualifications on the record for the board. Could you please give the board the benefit of your education and experience?
Sure. I have a master's degree in civil engineering from Rutgers University, as well as master's in mechanical engineering. I have a bachelor's in surveying from NJIT. Currently hold a professional engineering license since 2004. Professional land surveyor since 2012, and a planner since 2014.
And have you testified before boards in the state of New Jersey as both a expert in engineering, surveying, and/or planning?
Yes, I have. I've testified before the Board of East Amwell, the Board of Adjustment, though.
And you've been qualified as an expert with regard to those areas?
Yes, correct.
I'd like to submit him as an expert both in professional engineering, land surveying, and planning, please.
I'll accept.
Thank you.
Okay, so you weren't here at the last meeting, but we filled you in, and you heard some questions and concerns that the board had with regard to the original subdivision plan, correct?
Correct.
Okay, so what did we do as a result of those concerns? And let's go through and explain Exhibit A1 for the board.
So, we have a lot area of 12.63 acres. We want to meet the 1.5 acre or the 2 acre and the 10 acre. And also try to meet all the setback of all the accessory structures. So it was like trial and error back and forth until we got it pretty close. So we have lot A, which is in purple, with no variances whatsoever. The lot area is 2.01 acres. We meet the lot width. Do you want me to go through the numbers, or?
Yeah, why don't we just go through
Let's
so
get
it's
them on the
there for the
record.
board?
Sure.
Yep.
So lot A, the lot area is 2.01 acres, where the minimum lot area required is 1.5 acres. The proposed lot width is 270 feet, where the minimum lot width required is 125. The proposed lot depth is 227 feet, where the minimum lot depth required is 200. The front yard setback proposed is 73.5 feet, where 50 is required. The rear yard is 123.3 feet, where 30 is required. The side yard, we have 114.1 feet, where the minimum side yard setback required is 50. And the proposed lot coverage is 9,971 square feet, where the maximum lot coverage required is 10,000 square feet. We have 3 accessory structure on lot A. They're all class 2, which is between 100 feet and between 100 and 700 square feet. The required setback from the side and the rear is 20 feet, and they're all 40 plus.
So as far as Lot A goes, we comply with all of the bulk and other setback requirements of the ordinance.
That's correct.
Okay, so let's go on to Lot B.
So lot B, the proposed lot area is 10.62 acres, where the minimum lot area required is 10 acres. The lot width proposed is 400 feet, where the minimum lot width required is 400 feet. The proposed lot depth is 627 feet, where the minimum lot depth required is 400 feet. The proposed front yard setback is, again, this could change. This is what we show on the drawing, but again, we will comply with the ordinance.
So when you say this may change, that's because you're measuring from a proposed building that will be built down the road.
That's correct.
Okay, so this is the building envelope that's being proposed right now. That does not need approval from this board because it's a single-family home, correct?
That's correct.
If, however, the Mattises decide that they want to build the home in a different location or larger, or anything changes from what's represented to this board, they would have to come back for an amended approval, correct?
That's correct.
I'm sorry, I didn't mean to cut you off, but go ahead.
So based on the building that we're showing on the plan, the front yard setback is 439.8 feet, where the minimum setback required is 150. The rear yard is 155.6 feet, where 75 feet is required. The side yard is 172.1 feet, where 75 feet is required. The proposed lot coverage is 0.05, where the maximum lot coverage required is 0.08. And on lot B, we have 9 accessory structure. 3 of them are class 2 and 6 are class 3. We meet 7 of them, we meet all the setback requirements as far as side yard and rear yard. And I have 2 structures that, let me see if this works.
I'm sorry for interruption. Could you please kindly maybe point to on the
Yeah,
plan?
yeah.
It would be-
That's what I'm
I
doing.
appreciate, thank you.
So this structure here, which is 814 square feet, is right below the northern property line. And this is existing. We have nothing to do with the lot, with the subdivision. This is pre-existing, non-conforming. The setback is 31.1 feet, where the minimum setback required is 40. And the second structure we have is this one here. It's kind of in the middle of the lot, right north of the dividing line. And the area of the barn is 845 square feet. It's a class 3 structure. And the proposed setback is 18, where the minimum required is 40.
Okay, so for that first barn, as you indicated, that has nothing to do with the subdivision, so regardless of whether or not we were here today, that is a pre-existing condition on the property.
That's correct.
Okay, the other one, we've taken as best efforts as possible to try to meet that 40-foot setback, but that results in an irregular lot line, correct?
That's correct.
Okay.
That's correct.
So that really is the only new variance that we are proposing by way of this subdivision.
Correct.
Okay. Go ahead.
That's basically the, just for the board's information, I mean, we had a nonconformity for the principal structure, which is the dwelling, is 73.5 feet, and based on the conventional lot, it should have been 150, so that variance is being eliminated as part of this subdivision.
So we're making the property
More conforming, correct.
Okay, did you have an opportunity to take a look at the review letters from the board's professionals?
Yes, I have.
Okay, so let's take a look. We'll start with the one dated March 11, 2024 from the board's engineer. And I'm just gonna go through some of the comments and have you address them. Do you agree that the applicant will obtain any and all necessary approvals?
Yes, absolutely.
And there's a couple referenced in there, so whatever submission is required, be it to Hunterdon County Planning Board, County Soil Conservation, Health Department, DNR, we will make those applications and provide the board with copies as well as their determinations.
That's correct.
There's also some references in there about amending the actual plans to comply with the map filing law, updating the zoning data table, obviously now in conformance with the new plan. Do we agree to do that as well? I don't think it matters, but we will comply with whatever it is in there. If we decide to do a filing of the map, then we would comply with that. Otherwise, we would always have the ability as a minor subdivision to do
File it by deed, correct.
So if we decide to go that route, though, we would obviously comply with the map filing law.
Absolutely.
Anything else in the board engineer's letter that you would like to address or that we cannot handle?
No, I mean, the board engineer requested that, whether we're doing stormwater, and obviously since we don't have a layout of the house completed yet, if we need to do stormwater, we'll do it.
And we don't have any choice. I mean,
That's
that's
correct.
not only a municipal or county, that's a state requirement.
That's correct.
So that could be a condition of approval as well, that we would comply with any stormwater management requirements. Okay, moving on to the board planner's letter, that's dated February 1st, 2024. Mr. Mattis did give a lot of testimony at the last hearing in response to some of those questions. The variances have obviously now changed. You indicated the two that we're asking for tonight, one of which is a variance from the rear yard setback requirements for the 814 square foot barn on lot B. Requirement is 40 feet. We're proposing, and there is an existing 31.1 feet and a side yard setback variance for the 845 square foot barn also on lot B. And this is a new variance based on the change in the lot line. 40 feet is required. We're proposing 18 feet. There are certain planning proofs that we must give the board in support for those variances, correct?
Sure, yeah.
Could you just give the board a little bit of testimony with regard to how we meet those and how they can grant the variances we're asking for?
Okay, in my opinion, this is like a C1 and C2 variance.
Can you just explain to the board the difference between those two?
Sure, the C1 variance is hardship, and the hardship being is we have all these parameters that we have to deal with and get the lot area meeting the zoning requirements. So I feel like it's a hardship by reason of extraordinary and exceptional situation uniquely affecting this specific property. And the C2 variance is basically a flexible C2, so what we have to do is basically prove that we're advancing one of the purposes of the municipal land use law, and we're not creating any substantial detriment to the public or the zoning ordinance or the master plan. So as far as the C1, I just provided you with the positive criteria. C2, I believe that this application, if the variance is granted, it will advance purpose 2G, which is to provide sufficient space and appropriate location for a variety of agriculture, residential, recreational, commercial, and industrial use and open space, both public and private, according to their respective environmental requirement in order to meet the needs of the New Jersey citizens. So here we're providing agriculture and residential in this specific location. And again, we're not building anything on the easterly side of the lot. All we're doing is creating this line that is invisible, and it divides the two property. So nothing is changing. Nobody would even know that there's property line and setback variance. So in my opinion, there's no detriment, or this variance can be granted without substantial detriment to the public good and will not substantially impair the intent and purpose of the zone plan and zoning ordinance.
And in fact, as you testified to before, we're actually removing one of the existing variances by way of the application.
That's correct. We're removing the front yard setback on the existing lot.
Anything else you'd like to say to the board?
No, unless the board has any questions for me.
I don't have any other questions.
I have some questions.
Go ahead.
Mr. Engineer, so a couple questions. One, the potential application for a C1 hardship variance. So is there anything inherent in, the property itself, or the physical characteristics of the property that makes it unique? Because it seems to me like it's perhaps not unique, it's just part of an existing larger lot that is being sought to be carved off.
Well, I mean, the lot we're proposing is kind of unique, right? I mean, it has an odd shape, and there is some slopes to it.
Well,
But again, we're dealing only with existing. All the proposed stuff is conforming.
well, right now, without carving off that lot, right?
Mm-hmm.
It's not steep slopes, right?
Correct.
It's not very narrow, so there's some impediment to being able to do something with it, right?
Mm-hmm.
So, is there anything else about the land that you want to create the new lot out of that makes it different than just a portion of a larger lot that an applicant seeks to make into
Again, it's just the fact that there was a lot of structures that we had to deal with in order to make this work. So the C1 has 3 prongs to it. The one is narrow lots. The other one is steep slopes, and what I described to you is the third prong, which is it's a unique lot with too many accessory structures.
Well, that's what I'm trying to find out about. So, unique is my understanding where there's something already about that property physically that makes it unique. Not that the use that you seek to use it would make it unique, right? It seems to me there's a difference.
I think, and you were saying the existing structures on the property as they are now
Yeah.
is what fits into that third prong.
That's
Not
right.
what they're looking to do, but what's there now.
It's the historic
What's
barns.
existing?
What makes it unique is that those buildings predate any kind of zoning.
So if anybody has an old barn on a property, they now have an ability to say it's unique and carve it out of 10-acre zoning?
Well,
Right, that's
presumably you wouldn't be penalized for a setback if you have a historic home that's too close to the street.
well, not unless you want to subdivide it and make it too close to the side setbacks or something else. So that's, I just wanted to find out what their basis was for saying that this was possibly, you know, a candidate for a C1 hardship variance, right? Hardship as opposed to something else.
And I think we also went through the C2 as well, so we can.
Yeah,
also-
so, right, so on the C2, I think if I understood you correctly, you said that, you know, providing the variances would promote open space. Could you tell me more about how that's so?
Well, that's the general, I read that, this is what, it's a municipal land use law.
Mhm.
What we're proposing here is to create agriculture and residential. I mean, I'm not providing you with industrial either, so, but the law states all that.
So, am I correct that, you know, allowing this smaller lot to be created won't result in more open space to the community?
Well, what Mr. Mattis last meeting testified that he wants to homestead there. So he wants to restore an old barn and do an ag use in the 10 acres that he
Well,
wants to
that
purchase.
was the other thing that they said would be a beneficial part of the application. He mentioned two things. One was open space, and the second was agricultural use. So I was just questioning him about open space because I don't see that allowing this variance would create more open space, and so I wanted to make sure I wasn't missing something. Am I correct that, I mean, that
What,
if we
what,
grant the
what we're
variance?
creating here is one lot for agriculture and a residential. I'm not sure
Okay.
if
I don't know
Greg
if-
testified to open space.
Well, I don't think the criteria is to create more open space per se. I think that what that criteria is intended to cover is that it's going to enable the properties to be utilized in a manner that would continue to allow for open space.
Well, is
If
there any-
this was,
I'm sorry.
it's okay. If this was one lot and remained one lot, there could certainly be a lot more development on it pursuant to not only your setbacks, but your impervious coverage. So by subdividing this and creating two smaller lots and having those setback and impervious coverage requirements applicable to each individual lot, you are in a way minimizing or maximizing the open space, I guess I should say.
Well, right now, there's a greater than 10-acre lot, right, and it's 10-acre zoning there, am I right?
Without this grandfathering provision,
Right,
which
so,
they're entitled to.
right, so there's a 10-acre lot, so whatever you can do with a single 10-acre lot, you could do. If this is subdivided, there would be more development, right, and less open space, or less, because you're now allowing more development that you would otherwise be allowed under the zoning.
Not necessarily, that's not how we're seeing it, but certainly if that's your impression.
Well, I mean, I assume this is gonna be, where are the existing structures? Are they, is there no structure on one of these two lots now?
Which structure? The principal is right here.
Okay.
The rest of them is, you know, it's mostly on the easterly side.
So the green lot, the larger lot, does that have a residence on it now?
No,
And that would be more than 10 acres in size after your variances, if you get those?
yeah, again, we're not requesting
Yes.
lot area variances, but yes, it's 10.64.
Okay. So there could be more development. All right, so that's why I wanted to ask about open space, because I don't see that there's any, you know, this wouldn't, granting this, the variances wouldn't provide more open space. So the other thing you said was it would allow agricultural use. And so is that agricultural use that you're saying is related to which of the lots or both of the lots?
My understanding is the lot B, the green lot,
So the larger lot,
the larger lot.
and that would be able to be an agricultural use where now it is not?
It's not being used that way now.
Yeah.
But it could, right? I mean, it's a 10-acre lot.
It could, but that's not the standard. The standard is what is the proposed project going to do, and what purpose and what benefit is it going to be giving? And the benefit is that now that would be agriculturally used, whereas now it's not.
Well, when you say it would be, is you.
Because my client's purchasing it and has testified to this board that that's what his plan is.
Right, but irrespective of that, if it weren't subdivided, am I correct that that lot would be allowed to be used for agriculture if someone chose?
Correct, but again, that's not the standard. It's because it's not being used now, and that's not the owner's intention. So it's what would this project give as far as a benefit, and the project, by way of the subdivision and the sale, would result in the agricultural use of that lot, whereas today it does not exist. Not whether it could, there's a lot of things that could happen on that property.
Well, but it's also not guaranteed that the buyer would in fact use it for agriculture. It's just that he or she, the
Well, he's
family could.
testified to the board that that's what he's.
Well, but the intentions change, because here we are 18 years later, and there's a different proposal now than there was then. So, I mean, nothing in the approval would guarantee that it's used for anything in particular, right? I just want to make sure I understand the application. So, as I see it right now, the lots could be used for agricultural. You're saying they're not, okay. But if there's a division, I don't see that it changes the ability to use it for agriculture unless I'm missing something. Because you could do it now or you could do it after a variance, right?
That is correct.
I have a question.
Me-
Is your
And then we'll
client
hear from our
buying both
planner.
parcels?
No.
Both? Okay, so we're going to have two different owners.
Correct. The other, yes, correct.
Which parcel is your client buying?
The green,
The 10 acres.
10 acres.
What is the purpose then, and you say that it's a grandfathered lot. I haven't seen any, no, there's testimony, I know that it's a grandfathered lot.
And your
But do you
ordinance
know
allows for it too.
what, excuse me?
It's in your ordinance also. That's where it stems from. Your ordinance, if you look at your planner's report, the ordinance section that this is grandfathered under is your Amwell Valley Agricultural District grandfathered lots section.
Okay.
So that's on page 3 of your planner's report.
Yeah.
It's a 2006 letter that references it.
May I ask why it's grandfathered? Because we're talking about currently a 12-acre lot.
Correct.
And now, how is the creation of a lot that is less than 10 acres grandfathered? That's what I'm confused by, and I think.
Can I say something quickly to
And
this point?
yes, and then I want to hear from our planner, actually.
All right, on the 2006 report, it says, "The planning board acknowledged that it has an informal agreement with the applicant to allow subdivision of 2 lots between 1.5 to 3 acres in the area in order to facilitate the sale of the 50 acres to Hunterdon County for public recreation." I think that's the section, and that is in the 2006 planning board report. This one. My question has always been, how long do these things last?
It's a good question.
Yeah.
We'll get to that.
Do you mind if I,
Yes.
John, Mr. Burry, I'd love to hear from you.
Sure. So you have the report from my office, and I didn't have any role in drafting it, unfortunately. But my interpretation is that the grandfathering provision is not what applies here, but there's the lot size averaging option that really makes more sense, because the lot that exists is not an undersized grandfathered lot. That would have to be the case for it to be grandfathered in. As everyone's rightly pointed out, 12+ acres doesn't fit within that 1.5 to 3 acre provision of the grandfathering clause. But there is a section of the ordinance that talks about lot size averaging options. And that's really what we are looking at in the history of this development over the last 25 years, I guess, give or take. Maybe, I'm sure longer than that, but at least the resolutions that were provided. So if we start from 1999, when we had 60-something acres, pieces started to get lopped off here and there. What we end up with today essentially is that lot size averaging situation where the big chunk went to the county fairgrounds, and you're ending up with essentially 3 or 4 smaller pieces, depending on where we end up this evening, that fall within those provisions. If you look at the overall density of the entire tract as it was at that time, it really falls under that density provision from that lot size averaging of 1 unit per 10 acres. Even though the individual lots are smaller, they're clustered up on the highway. The rest of that land remains open in perpetuity. So that's kind of the balance there. I don't see how that grandfathering provision applies, but we end up with the same zoning standards with 2 different sections of the ordinance in a way.
Could I ask a follow-up question?
Yeah, that's helpful.
Yeah,
Go ahead.
so could you tell us more about how the doctrine of lot size averaging works? And are there time constraints on it? I don't know much about it. I've heard the term. If you could explain, that'd be helpful.
Well, I wish I had a better sense of the history of this. I wasn't here for the last 25 years to know, because the resolutions talk, there's so much discussion of informal meetings and intentions and agreements, and I want to assume that everybody's been acting in good faith this entire time. And it seems like the plan is sort of unfolding over a fairly long time horizon, and we're getting somewhere in the neighborhood of what was talked about way back when. I don't know how it's exactly evolved over time. So as far as a specific time horizon, you would usually have a concept plan that would set that out. It may unfold over time, and the ordinance allows for these re-subdivisions to occur as long as they're at least 12 months apart. So it doesn't say you have to do them within 2 years, 3 years, 5 years. It says you can't do them more often than every, once a year, unless you're gonna do them all at once in a major subdivision. So I don't know that the ordinance sets any specific time horizon on it, and without that clear guidance, I don't know that we have, it's sort of up in the air.
Because I would imagine that if someone has a large parcel, that kind of doctrine wouldn't allow the homeowner, the landowner, or a successor landowner to keep, making changes and carving off lots, and then say, look, so long as the carve-outs, average under 10 acres, because it seems to me that would have a potential for undoing the overall zoning, and especially over time, that becomes more of a concern, because if there's not a rule of reason, where that kind of thing would have to be worked out up front, memorialized, and then parties follow it, then I would be concerned that our zoning would be subject to constant change, because we're a place with large lots.
Sure. Well, I think the linchpin to the whole thing is the preservation of the big tract. If that doesn't happen, then the lot size averaging doesn't happen.
And so
Well, it isn't a big tract. It's the minimal size tract in the valley.
No, they gave up
Understand.
50 acres.
What?
That
Yes.
already happened.
No, I'm
Yes.
talking about 10-acre zoning. It's where there is 10-acre zoning.
Yes.
Right. So typically you'd need 20 acres in order to have two lots. You're asking us to have, and one is 10. We understand that. That means 10-acre zoning. The other is 2.5, and you're telling us that it needs 1.5 acre zoning. When's the last time we had 1.5 acre zoning in East Amwell?
Well, you have it right now under certain circumstances.
No. When's the last time the zoning of the valley was 1.5 acre? Where this property is located. When is the last time there was 1.5 acre zoning?
Right now, if there's certain circumstances. I don't know if it was ever 1.5 acre zoning generally. That's
No.
before.
Well, yes, East Amwell had 1.5 acre zoning, and then East Amwell changed from 1.5 acre zoning to 3.5 acre zoning and to 10 acre zoning.
I think what he's
What-
trying to say is that there's still, that may not be the norm now. The norm may be the larger lots, but in certain circumstances that fall within your ordinance language, that 1.5 can and is still a valid lot size in the valley. And the other thing that I think makes this
I don't think so.
Yeah, what circumstance would those be? Because I'm not familiar with that either. Maybe the
Does-
attorney could answer.
Is it relevant to this?
Well, I think
Well,
what Rich is trying to find out is how we're getting from an ordinance that says 10 acres to now as low as possibly 1.5 acres. So,
But I think we have to remember that 2006 planning board approval, and we can't forget about that, because in exchange for the 50 acres that were donated and sold to the county, there were certain agreements and representations that were made to the owner of the property. One of which was that there would be allowed an additional subdivision of between, one lot being between 1.5 to 3 acres. And that's what we're coming back to do now.
but wasn't there a promise at that time, because I read it in the record, that said there would or could be a soon application to do that? Because again, we're 18 years later, and
But
so.
there was no time period in the resolution
But there was also no
itself.
guarantee that it would happen, right? It was dependent upon someone making an application, and the representation, as I understand it from that record from 2006, was that it may be applied for by the landowner shortly. And so if it didn't happen, it doesn't make that, one, it doesn't sound like that was ever an actual requirement in that agreement. But two, even if it was, it seems like that would have to have been acted upon in the time frame contemplated by the parties at the time they wrote that 2006 resolution.
And I think we would just submit to the board, you know, certainly I do hear what you're saying, and at best, it's unclear as to whether there was any sort of time period. And I would say in order for a specific time period to be enforced, it would need to be in there. Otherwise, it's up to this board to interpret what was meant at that time and to impose a drop-dead deadline when it wasn't specifically in the resolution. I would say most certainly creates a hardship on the applicant and, you know, possibly even more, because how could they be held to something that wasn't specifically outlined in the resolution?
Well, the testimony I remember from the last meeting was that in order to apply for subdivision, you had to do a test to make sure that the area that you were going to have septic would perk.
Correct.
And because at that point there was no buyer identified, the applicant wasn't going to spend $800 to have that test made until the buyer who wanted to homestead on the larger lot came along.
Right, but so query, so if you accept that approach, so query, how long could the landowner wait? 100 years, 200 years, right, for some applicant to come forward? And also, in terms of a hardship for this applicant, I would submit, it's not a hardship to this applicant if the owner of the property in 2006 chose not to move forward with whatever the discussion was that we see recorded in the resolution. To me, that doesn't sound like a hardship, that sounds like a choice the landowner made. And now this applicant is trying to get a variance so they can do that. So to me,
I mean, what I heard last time is this applicant came purchasing a lot that he thought was already deeded, entitled. So the hardship is that they're having to go do all of this to basically memorialize an agreement that was made in 2006. So he can
And-
fix up a barn and homestead.
And I'm
Well-
sorry, and if I may,
I
this
don't think
lot
that's so.
line right now is drawn in an effort to resolve certain concerns of the board. We could do an irregular lot line, maintain the two sizes that are required based upon what we've heard tonight, and do away with that setback. And then there would be nothing that this board would have to grant by way of variances. The only thing you would have to grant is a minor subdivision. And I would submit, although this board of course has jurisdiction, you'd be hard pressed to deny a minor subdivision without variances. So
well,
we're
right,
trying
but we'd
to
have
do
to apply the
this.
variance standard to determine whether variance is appropriate, right? That's our duty.
But what I'm saying is we're here asking for the variance because we were trying to give you the lot you were looking for.
Well, I would say respectfully, we're not looking for any lots, right? We're the planning board, and we're considering an application from an applicant who wants to vary from our very important 10-acre zoning. So I think that's really the context. But I just want to, in this part of it, just find out the facts so that I can understand.
And I have one
what the
question
law is.
also. On the gentleman's agreement originally, which goes back to, I don't know who the original owner was would that still be a valid agreement all this time later to another third party who's owning this property or wants to purchase this property?
Well, again, it was the.
I understand that, but who was that for? Who was that with? It wasn't for Mr. Mattis.
No, Mr. Mattis is the purchaser. So Mr. Zimmerman is the current owner, and he was involved at this time.
Right.
So,
What I'm asking is that still a valid agreement
well,
to subdivide?
We would, of course, submit to this board that it is, because there was no time period placed on this. And I think it would be very difficult without letting Mr. Zimmerman know. And I think that what Mr. Kadri said is absolutely true. Until he had somebody that was going to come in and spend that money and have an actual interest in buying the property, then there was no reason to do a perk test. Had there been a 10-year time period in here, then very well Mr. Zimmerman would have been made aware of that, and he might have spent the money to do the $800 perk test, or however much it would have cost at that time, and come in for the subdivision, because he would have been on notice that he was losing his rights because that time period was in there. But without that there, he has no notice and no ability, because there was no end game. Municipal land use law sets out certain end games for when you have to act on certain types of approvals. That wasn't in here. So that's what I would submit to the board. He had no ability to make that decision at that point.
Well, I mean, respectfully, I think you're putting the burden in the wrong place. You're putting the burden somehow on the township, when in fact the burden's on the applicant, right? Or they're the landowner, to take advantage of what the landowner thought the agreement was. And it's certainly not on this board or on the township that no one wanted to buy a piece of land, right? So that's not the township's burden, respectfully. That's was a choice of the landowner, and I can understand why the landowner would wait if they felt that was in their interest. But I don't see how that's a failure on the part of the township to give requisite notice. I think whatever the agreement was, and I've read the notes, and it says that the applicant intended to come back soon if the applicant wanted something. And again, here we are 18 years later. In my mind, I'm concerned that the applicant did not follow the procedure that was agreed to it back in 2006. So.
I think we'll probably choose to disagree on this
No,
one.
I totally understand. I totally understand. Thank you.
Thank you.
I appreciate the opportunity to ask you the questions.
No,
Thank you.
please, and I, honestly, I wish I had better answers for you. You know, resolutions, as you well know, are quite different nowadays than they were back in 2006, and hindsight's always 20/20. I feel that this property owner and this applicant is looking to do something good for the town, looking to make this a viable use of the property, and got stuck here because something should have been actually, and again, the testimony was thought it was done all these years ago, and now when we get to this point, find out that it was never done. So now this is where they are, and it would be a shame for something that was unclear to not allow him to do this for the board.
I have a question. Why doesn't he just simply sell Mr. Maddox the entire property?
You'd have to ask Mr. Zimmerman that, but I'm guessing he wants somewhere to live.
Does Mr. Zimmerman still live on the 10 acres?
In the purple.
No,
This is the purple.
Oh, he lives on the
Well,
same
lot right now, correct.
So why does Mr. Zimmerman want to sell, so he wants to basically sell the 10 acre lot for money, basically, to get more money, obviously. I mean, there's a value, right, to a building lot as opposed to acreage. So he has a house existing on that. And I assume, right, he hasn't paid taxes on a subdivided piece of property. If that was subdivided 16 years ago, and it was...
If the taxes were not paid in full, we wouldn't be able to do
No,
before this board right now.
you didn't understand. If that property was subdivided into 2 parcels, right? He'd have paid taxes, real estate taxes, on 2 parcels for 18 years. Would he not?
I'm sorry, my client was asking me something. What were you saying?
Your client was asking you something, or the engineer was asking you something?
They were both asking me something. I don't know how all of a sudden this just got very contentious. I certainly
I
didn't
don't mean to be
to.
contentious, but I'm asking a question, and you're telling me you're not listening to my question, you're talking to your clients.
I'm sorry, Mr.
Sorry.
Kenton.
All right, thank you.
Please ask your
Right.
question.
My question is, right, first of all, at the time, I don't know whether the zone, whether in East Amwell, but I'm pretty sure it was, the zoning requirement was 3.5 acres,
And when are
not,
we talking about? What year was that?
I'm asking you the year, because you have this fluid year, 18 years, whenever you decide to do it.
Mr. Catenacci,
What?
I'm gonna just say, we don't have that information in front of us, and I want to kind of try to bring us back to what we're asking to decide
Okay.
today,
Yeah.
if you don't mind.
So I have a couple things to add. I didn't really want to interrupt the board. But one thing, I know there's a lot of concern about the 10-acre zoning that the municipality works really hard to maintain. I think it's important to remember that your decisions here aren't like courts, right? They're precedential, meaning that every application that comes before this board stands on its own merit. So if another applicant were to come in from zone and say, hey, Mr. Mattis did this, in 2024, that doesn't mean anything to you, right? This applicant and any other applicants that were to will come before this board if you so choose to approve this application, will have to meet their own burden, right? So I think that's important to remember. Secondly, remember what we're here for tonight, which is a minor subdivision with now 2 bulk variances, correct?
Correct, one's pre-existing, and if I may, what I was discussing with the engineer and the client was, he doesn't have a problem demolishing that barn and doing away with the 1 variance, if that does anything. I mean, I don't really think that's the issue here, I'll be honest. I think we're trying to work out some other things, but, that certainly puts before you what we submit as a fully conforming minor subdivision, with the exception of a pre-existing structure that's not being changed at all.
And at least for the standard, so, but I think we need to separate out the minor subdivision and then the variances that are coming from that minor
Yeah.
subdivision, right? So we have a minor subdivision, right, that's happening. Which a minor subdivision is, generally speaking, the board your duty for a minor subdivision is to make sure that what the applicant is proposing, subject to variances and waivers, is consistent with the ordinance, right? That's 1. 2 are your bulk variances, which because of this subdivision, there are no bulk variances. One is a pre-existing bulk variance, and the other one is, let me see, we changed them.
It's an accessory
18 feet.
structure.
Yeah, it's an accessory structure, right? Which is the only resulting bulk variance from this actual subdivision. So the standard that we have to meet, as we talked about, is positive and negative criteria. There are 2 ways to meet positive criteria, right, that we've already talked about, either hardship or flexible C variance, right? So there's 2 ways, and then the negative criteria, substantial detriment to the public good and substantial detriment to the zone plan and zone ordinance. So let's try to, in our discussion, let's try to think about the criteria that we have tonight. And also remember that it's not precedential, right? So if you find that the applicant meets their burden for both the minor subdivision and the bulk variances, then it would generally, warrant an approval.
Mr. Nardi has been waiting
Yep.
patiently,
Sorry.
and then.
Yeah, it's fine. A couple of questions for you. Any proposed changes to the drainage patterns on either one of those lots?
Not in connection with the subdivision. So depending upon what this board decides tonight, my client does intend to build a home on the 10-acre parcel, 10+ acre parcel. At that time, he will have to comply with any and all stormwater management, local, county, state requirements, based upon the disturbance of more than an acre and whatever it is that he would need to do at that time. So based upon what those final drawings will be, certainly he would have to comply with everything.
Okay,
So I
just
don't,
wanted to get that on record.
no,
Okay.
absolutely, 100%.
Also, any proposed screening between the 2 properties? I mean, I don't know what the future is gonna hold, but, you know, the person, the gentleman that's gonna live in that one house in the purple area, I mean, is there any proposed screening between the two lots? Like along the drive or anything like that? I mean, like arborvitae's, things of that nature? I'm not talking like, you know.
No, I understood. What we're, okay.
That's fine.
So, I don't think we would have a problem with that, but I just want the board to know that, you know, Mr. Zimmerman wants to live in that property right now. When he no longer does and he's looking to sell, my client's intention is to buy that one too.
Okay.
So, we didn't want to put too much, because again, I don't want to muddy the waters, and I thank you for doing that, because there's a lot of moving parts here right now.
And
but
history.
Yeah, and a lot of history. And a very, very unique situation here with this resolution, with the county, with the 50 acres, with everybody trying to work together to get to an end result that now, yes, is not the way your ordinance reads with regard to most of the properties in town. I mean, we're not saying anything here that is not completely accurate, but this is such a unique situation. And Mr. Mattis wants to buy it. You see his family coming here tonight. They just want to build a house and they want to live there, and they want to let Mr. Zimmerman live there for as long as he wants to as well. But ultimately, they're looking for that entire area. So I just want to, so if some arborvitae there right now would be beneficial, then fine. But that's the ultimate end game, so I don't know,
Okay.
you know, if that's something.
Can I ask
Thank
Mr.
you.
Mattis a fast
Miss,
question?
may I ask, I want to recognize Ms. Wiggum.
Oh, I'm sorry.
Yep.
I was curious, you said at the beginning there was gonna be an easement built in now to allow access to what building?
So that barn, if necessary, which again, now we're, you know, indicating
Now
that
there's
that
several
may not
barns.
be necessary. Is that the one that we're talking about that you would need access to?
Yeah.
Yeah, okay. So to the extent that that may remain after this, Mr. Zimmerman would like to continue his use of it. If it can't remain, then that's something we'll deal with. But that's the intention.
So
And
what
again,
you're saying is,
I don't think that one bulk variance is really the big issue here.
just so I understand, you're basically saying that should we not approve that bulk variance, the way to get around it would be to destroy the barn?
Correct.
Okay. I just want to make sure I understood what
Yes.
you're saying.
Yes.
Ms.
I hate to
Mattis,
use that word.
fast question for you.
Okay, I used it.
I know, it's okay.
Now, you wanted to do farming here, Ms. Mattis, is that correct? You wanted to do a lot of farming?
Is-
Are there a lot of smaller buildings on this property that you would have to take down to do your farming? To make it for better acreage for yourself?
So there are numerous older buildings that are pretty much teetering on either saving or pretty much the weather takes them and they fall down. I'd like to save what I could to use. My oldest son, who's 5, he's really getting into chickens, and we wanted to turn one of the buildings into a chicken coop. We want to grow a variety of vegetables, probably some Christmas trees. There's a concrete pad that remains next to the large barn. I'd like to put up a greenhouse to be able to, you know, start early growth with the plants. Just, you know, you saw my 3 kids.
Yeah.
They're kind of into, you know, the animals and things like that. We take care, we do a lot with the 4-H for the fair. I want to get my kids into the 4-H program. I think my 5-year-old is going to register for the Fur and Feathers program with the chickens and everything like that. And this just will give us the ability to move forward.
Gotcha. Thank you.
So, what I can save, I want to save.
Understand. Thank you very much.
Do you have any more, Mr. Burry?
Just one question. I listened to the recording, but some of the testimony was a little hard to hear, so I just wanted to make sure I
No,
didn't miss
please.
anything. For the existing building on the purple lot, for lack of a better word, I guess this is Mr. Zimmerman's house, is that a single-family dwelling or a two-family dwelling? There's some reference in a variety of the resolutions to a two-family home, and just want to clarify on the
Two-story.
record whether it is in fact a single-family or two-family. It's a two-family home. It's a two-family.
Which my kids live upstairs.
Well, so you're all one family.
One family.
be two families,
Yeah,
but.
believe me, you don't get no rent, it's the same thing. You know what I mean?
Correct.
So from it's a pre-existing two-family home, it's been there for some time, the resolutions mention it. But it's non-conforming, is that accurate to say? That's a question for you, Mrs.
Correct.
Yeah, I have not looked at that issue. If that is the case, then it would be pre-existing non-conforming.
Right. So, from a planning standpoint, when you reduce the area of a lot on which a non-conforming use sits, then we'd be looking at the expansion of the non-conforming use typically, by virtue of reducing the amount of land that it has on which it be. Is that accurate to say?
Yes, it is.
Okay. So where are we with our application in light of that?
That has not been an issue that's been raised up until this point. There has not been a discussion of that. I don't know, how long has that property been utilized as how long, well, you've been there since at least.
I've been there since the 90s. It's been in my wife's family for 115 years.
There is reference in some of the one of the resolutions, I think, to an existing two-family non-conforming home. And I think this it specifically states the planning board accepts that it's non-conforming, or something along those lines. Like
I don't dispute that. I mean,
Yeah.
It's clearly a record that it was acknowledged as such.
Yep.
Where I think we may have an issue though is that the zoning standards, especially for the lot size averaging situation that I referenced before, talk about single family dwellings.
Okay.
And if we have a two-family here, I don't have any indication that that same provision is permitted. There's accessory dwelling unit standards in the ordinance as well, where you can have a second unit if your lot's at least 10 acres. So under the current situation, you can say that it's not non-conforming, but under that provision, it meets those standards. But if the lot area is reduced, then it may either exacerbate an existing non-conformity or become non-conforming as to the use of the property.
Yep.
And that's my concern, just to clear that up.
Okay. Thank you.
I mean, certainly we could ask for whatever other approvals may be necessary in order to get that to be allowed to continue. That would really only be my only suggestion at this point.
Well, I have a question for our attorney, if I may, on that issue. So what happens, I mean, I understand generally that, let's say if a house is on a small lot and then the zoning requires a larger lot, it's grandfathered,
Yeah.
right? What happens to the status of a structure that's grandfathered if the size of that lot changes? Like, especially here as proposed, it would get smaller. Can a grandfathered lot continue to have grandfathered status if the lot size is shrunken? You know, separate apart from the planning concern raised by our planner, is there a legal ability to continue that grandfathering with a changed lot size, even smaller than the zoning?
So I think the issue that our planner raised is that it would be, so since you're reducing the lot size, you're changing, I would say exacerbating, not changing, because normally you think of it as expansion, but exacerbating a pre-existing non-conforming use, right, which would be a D2
Can you speak a
variance.
little louder so everyone
Sorry.
can hear you?
So,
Especially people like, no, I'm sure no one.
so what our planner just raised is that when you have a pre-existing non-conforming use, right, a non-conformity that exists prior to zoning, right? So exactly what the mayor just mentioned, that you are entitled to certain rights as a result of that, right? But when you go, an applicant goes and exacerbates that, right, that non-conformity, you have to seek a D2 variance, right? So it's a different type of variance. It wouldn't just be
Oh, I see
a
what you're
bulk,
saying.
right?
Gotcha.
You're,
So-
you're exacerbating the non-conformity here.
Right.
Oftentimes you think of it as making a structure bigger, right, that's non-conforming, or making it closer to the setback that they're within. But here, you're exacerbating the non-conformity.
You're sort of increasing the intensity.
Yes,
For-
of the non-conformity.
But it's really not exacerbating anything, because none of the existing conditions are changing. it's currently occupied.
Other than the lot size.
Yeah, other than the fact that the zoning right now calls for 10 acres, and this is already an exception, and now it's becoming arguably a greater exception because we're exacerbating the departure from our standard.
See, I don't-
So, I mean, I see what you're saying, like on the ground, you might look at it as not so different, but if you're looking at the principle that we're trying to zone uniformly, then I think it clearly has to be exacerbated.
I think it's really a situation where, under the lot size averaging situation, like I said, it talks about single-family dwellings.
Yeah.
So, single-family dwellings, if this, we have some testimony now that it's a two-family, and maybe they're debating that. But, the ordinance also allows for a secondary dwelling on the property, but that has to clearly be a minimum 10-acre lot, and I would posit that right now, as a 12.5-acre lot, that the principal dwelling with the secondary dwelling is probably conforming. I don't know for sure, but based on the size of the building and the parameters of the lot, it's probably conforming. So what the subdivision does is puts that on the small lot, where it doesn't have enough lot area for the secondary dwelling. And now I don't know if we can apply the lot averaging standards, because it's not a single-family dwelling.
Is it a secondary dwelling, or is it one, I didn't.
And that's what I was gonna say, I don't really know where the two-family came from, I mean,
It's in the resolutions.
No, that I know, and obviously I don't have the history of that either.
It's a single
I know
structure.
that one family lives in there now.
Yeah.
You
Okay.
know, that, you know, he's testified that it's, you know, him and his son, you know, and so.
Okay.
So I'm not quite sure, that's what it seems to be currently used as.
I mean, maybe the solution, maybe, if the board's acting favorably, is to say that it is, to affirm on the record that it's a single-family dwelling, and we'll move forward.
I mean, we could
I
have
don't
that
know.
conversation.
I mean, if it's,
Again, I don't know where the two-family came from other than what's in here, so.
Well, I
It
think we
doesn't
probably
seem to
need,
outline that.
I think we
You can
probably
have a
need to know the
two-family
answer.
house with members of the same family. I mean, two brothers can have a two-family house.
That's true.
So it's a two-family house or it's a one-family house. It doesn't change depending on whether or not someone is paying rent or not paying rent, or whether you're letting somebody use it for free, or whether you're giving it to a child, or whether it's, you know.
So,
It's the house, not who's living there.
What?
It's
Ms.
the house,
Kaczynski.
not who's living
It's the
there.
house.
Where are we
It
now?
probably has two separate, does it
not
have,
quite sure.
I'm sure it has two separate entrances.
we can, open to the public if you're finished with this witness. We have our engineer to hear from still.
I would, yes, I'd like to hear from the public, I'd like to hear from any other comments that your professionals might have, and any other questions the board may have, and then we can decide where we wanna go from there.
Okay,
Thank you. I just wanted to talk about the monumentation and whether this is a minor subdivision. Section 92-60 of the ordinance requires property corners to be set for minor subdivisions. So I believe that's why there was a requirement that this be done by plat.
Okay.
I think that's just simply going to lay out the boundaries of, if this is acted on favorably, where this new lot is actually carved out, et cetera. So I think that's why it needs to be
And that was section 92-60?
60, correct.
Okay, thank you.
So I think that's, we need to have that
okay,
understood, that it does need to be done by a plan, a final plat.
okay.
Thank you. That's all.
Anything else? Okay. I'm gonna open to the public for questions for, let's see, Mr. Mattis.
At this point, I think.
I think it's just everybody. Yep, okay, I just double checking here.
Procedure.
May I have a motion?
So moved.
Second.
Second? All in favor?
Aye.
Okay. One at a time. Mr. Wolf, you're up.
Mr. Wolf, on your way up, do you recognize that you were already sworn?
Yes, I do.
Thank you.
I have some papers, so I'm going to spread out a little bit here.
Okay.
And I apologize if I'm a bit disorganized, but I took a lot of notes and I tried to organize them while I was taking them. Let me start by trying to establish a baseline so I could ask some questions. If I own a 65-acre lot, and I agree to donate 50 acres of it to the fair, and in exchange, the township agrees that I could take that remaining 15 acres and divide it into 2 lots, one that's 12.5 and one that's 2.5. And I do that. And the township agrees to that because I could have divided it into 3 lots when it was 60 acres. So the township says, great, you're going to give 50 to the fair. We'll let you take your remaining 15 and divide it into 2. Even though if you only had 15 acres under our zoning, you couldn't divide it into 2. And I do that. And that's what happened here. Then 18 years later, I come back to this planning board and I say, I'd like to hive off another 2.5 acres. So I'll have a 10-acre lot and a 2.5-acre lot. And the planning board says to me, Rick, you can't do that. It's 10-acre minimum. And I say, but wait a minute. If we go back in time, once upon a time, I owned 65 acres. I could have broken it into 4 lots at that time. I believe under the law, the planning board would say to me, sorry, that ship has sailed. You got your approval 18 years ago to break it out into 3 lots. You can't turn back time now and say, well, once upon a time I owned 60 acres or 65 acres. I could have done it then. I should be able to do it now. That's what's happening here. And that's what I have a problem with. There's one exception between my example and what's happening here. And that is this Planning Board Resolution 2006-20. And this resolution has not been, in my view, accurately represented. If you read this resolution very carefully, it uses the word informal 4 times. There were informal meetings. There was an informal agreement. Things were informally agreed to. The planning board acknowledged that it had an informal agreement. Now, the person who drafted this was a lawyer. The clerk at the time was a lawyer. The use of the word informal, I have to assume, was intentional, particularly that it was used 4 times. So there was an informal agreement. Had there been a binding obligation on the township to allow the subdivision that's being asked for here this evening, this wouldn't have been an informal agreement. They would have had a formal agreement. There was also a misstatement earlier this evening that the owner didn't want to come in and spend the $800 until he found a buyer for the lot. Let me read from this, verbatim. Next year, soil tests will be performed on the remaining acreage near Route 179. And assuming the soil tests are favorable, then the applicant expects to return to apply for an additional building lot as informally agreed to. The way I read this is the planning board was expecting this to be done within the next year. He comes back to the same planning board that he had the informal agreement with, and they would sort this out. The notion that he has 18 years or 50 years to sort this out isn't supported by this. It says next year soil tests will be performed. So the only leg that I think the applicant has to stand on in the minor subdivision, to me, doesn't hold water here. Not at all. This doesn't support it. A couple of other things that I'd like to go to, having to do with mainly with the variances, but I think it also bears on the minor subdivision. First of all, permitting this subdivision is actually going to reduce the agricultural land available on this parcel. Because right now, well, I don't want to jump over that, but where that house is, where that new house is proposed to be going, is agricultural. That new house is going to eat up agricultural land on this property. And It presumably will have some sort of yard. You're not going to farm right up to it. So we're actually losing farmland with this. We're not gaining farmland. We're not gaining open space. We're losing farmland with this. How putting a second house on this lot advances the purposes of East Amwell, as the engineer said earlier, I don't get that. I don't understand how putting another house on a 12-acre lot that already has a two-family dwelling advances the purposes of East Amwell Township. To me, this impairs our zoning ordinance. It goes against it. I mean, bear in mind, in 1999, this township changed its zoning in the agricultural district to 10-acre minimum. This town was sued over that by the Farm Bureau, by a group of farmers, and by a developer. We were sued over that ordinance. We went to court and litigated that ordinance, presumably spent hundreds of thousands of dollars in legal fees. The judge issued a 71-page opinion, Judge Hens, finding in favor of the town, on the ground that there were valid reasons for this minimum 10-acre zoning. People fought hard for that. People got death threats over that zoning ordinance. Going against that zoning ordinance should not be taken lightly here in East Amwell Township. It should only be done in very rare and extraordinary circumstances, and I don't see that here. Particularly since, as they've said this evening, this gentleman is willing to buy the entire parcel. The notion that it's going to be agricultural, that the buyer is going to make it agricultural, I don't question the veracity of that statement. 2 years from now, this buyer could get a great job somewhere else and be gone. And the next person could use that lot for who knows what that's not agricultural. There's nothing that's going to commit this lot to agriculture from time immemorial. In fact, at last meeting, the notion was that the barn was going to be restored for agriculture. Now tonight they're saying, without really batting an eye, we'll knock the barn down.
No, different barn. Different barn.
This isn't the big barn?
No.
This is the
It's
smaller
one
barn. Okay, I'm getting confused with my barns. Okay.
There's a lot of them.
Okay. Then strike that. I'm trying to think of, see if I had, just give me 1 minute. I want to see if I have anything. Also, once this house is built, there's no going back. In other words, if the obligation to make this agriculture, there's nothing binding on that. Once this house is built, if this gentleman decides he doesn't want to farm it, there's no going back. If he wants to make it a big yard with swing sets and a swimming pool, there's no going back. We can't go in and say, oh, well, you told us it's agriculture, tear down the house. There's no going back at that point. So the bottom line is, this township should not digress, should not back away from the 10-acre minimum, except in incredibly compelling circumstances, and you don't have that here. And there's no commitment in this 2006 ordinance that someone could come in 18 years later and ask for that. And that's the only basis that anyone that I could see could even possibly rely on for this. And that's just too thin a reed. I appreciate the time. Thank you.
Thank you. Anyone else? Anyone else? Go ahead.
I thought long and hard about standing up. Chairman Early, East Amwell.
Could you
Can
go
I,
right in
Maria,
front?
do you swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
Come up to the
Tam,
mic.
can you go up to the mic? Tam, can you go up to the mic? Thanks.
I don't really have an opinion on what's being proposed, but I am concerned about this new variance. I think Alexis is right. I think being as that existing house is a two-family home, it is a D2 variance. That's not in the notice, that's a use variance. That usually makes the notice defective. It also makes this a zoning board case. I'm not sure the planning board, as you are sitting now, has a jurisdiction to make a decision on this case. I just throw that out there, and I'll leave it to the attorneys to talk about, but I think you got a problem with a D2 variance.
Anyone else from the public? Going once, going twice, close to the public. Ms. Kozinski, what do you want to do?
Well, I think we are going to regroup,
Okay,
and for a number of different reasons.
Okay.
What I would ask the board is if there's anything else, any other questions, anything else, other than what we've discussed tonight, that you'd like to have answered, that you're looking for any, again, aside from not liking the subdivision issue at all, and that's of course, our burden as it always is to prove. Is the lot line better, worse? Any thoughts with regard to it? Just anything. I would just ask so to make sure that when we come back, it's meaningful for everybody.
I would like clarity on where the statement that the existing two acres or 1.5, how that's grandfathered. I went through the record and did see it. To me, it would have been another variance, but I'd like clarity on that.
Okay.
Anyone else?
I guess we also need clearance on the two-family house, that
Yes.
information.
Yes,
too,
yeah,
from that
yes, that is,
I have that.
thank you for, yes, that is
And
one
I
of the
have that
issues.
and a number of others as well.
One other quick question, the existing wells, so with the new lot line, is there any issue with what structures they're serving? Can that be vetted out somewhat to make sure, just to make sure it's staying on your lot?
We don't have to deal with it now.
Right, that's just a question.
Yeah.
It's probably simple enough to answer, just to make sure. Thank you.
I have a question, and that's for the engineer.
Sure.
We have the zoning analysis for the two proposed lots, right? But we don't have for the existing 12 over 12 acres.
It's actually there. If
It
you look-
is there?
It is, yeah. If you look at the
It's on
zoning
the
table,
plan?
it is. The
Okay.
top part of it talks about existing lot and
Lot
lot
B,
B.
yeah.
So wherever it says
Okay.
existing, that's what it is as a whole.
Okay.
But you bring up a good point, that wasn't clear to you.
Yep.
So
Okay.
maybe we need three.
Yeah.
Maybe we need
I-
one for what's existing, one for lot A, and one for lot B.
Yep.
I'm used to seeing this as in the main basically table. You always had the existing lot and all the zoning analysis, and then you split, and it usually goes on the same exhibit. So it's easy. It's more transparent when you explain. That's all. I appreciate.
No,
Thank you.
absolutely.
Go ahead.
Could we also get clarification about the easements that would be required under if this were granted, and what that would mean for the deeds in perpetuity if both properties changed hands?
Sure, and again, I don't think that the easements wouldn't really be easements that would require board approval, but just more between the property owners to
Right.
make sure that based on the lot line, they were still able to utilize certain structures that they may want to. Now, a lot of this may change after we go back and have this discussion, but certainly, the testimony and what I've been told so far is that would not change with, new owners. Once the, Zimmerman lot was sold, that would cease to exist. But again, we've got some work to do, so I'll clarify that as well.
And I have a request as well. Is it possible for you to make copies of that exhibit for the board,
Yes,
please?
is that, can you see that?
No,
No.
from
No.
here you
No.
can't. You have to look at your electronic
No, but
version.
can you see the one, the electronic, but can you see the one I handed out? I mean, I can make copies. I didn't because I didn't think they helped.
Yeah.
I don't think
I thought
That's already in the.
I printed it. I thought it was
I didn't,
Yeah,
personal.
I didn't see the
All right.
electronic copies. I mean,
Yeah. I found the electronic
The
most
brain
helpful.
ones.
That exhibit does. I can't see it. Yeah. Anything else going once? Okay, Candace, out with it.
I'm not sure this is a fair question, but if Mr. Mattis ultimately is going to buy the Zimmerman property as well, what would he do with that two-family house?
probably just keep it as a single family for one of my kids.
Let's,
Yeah.
these are
Yeah.
questions that we are gonna go back and we're gonna go talk about and come with a full picture of what we're gonna present
Yep.
to the board.
And one more thing, since I'm newbie here. So, what is the use of the current lot? It's Mr. Zimmerman, right? It's owner.
That's his home.
Okay, he's home, right? But how about land and barns and everything?
Is there any other activity? Is
What
that your
what
question?
kind of activities are there?
We'll
Thank
get
you.
that for you,
Thank you.
absolutely.
Okay.
So before we go, Ms. Kaczynski,
Yes.
would you like to at least continue notice, right, continue the application to next month? And then if there is a need for you to
Correct.
renotice for a
Correct.
D variance,
Yeah,
that'll be
because some
done.
things might change, like I
Yeah.
said, with our discussion, so.
Okay.
I'd like to at least have that as the
So we'll
option. Certainly, if the circumstances we've discussed tonight have not changed, I would have to.
Yeah, so if we, what we'll do here is we'll continue the application as is, right, without additional notice right now. If that changes, where we've realized, the applicant realizes a D variance and professionals realize a D variance is necessary, obviously notice would be
We'll have to
required.
switch gears.
Obviously, yeah, but, I just want to make sure that if you do stay with this application, if you'd be willing to submit just a letter to the board to continue our time to act.
Absolutely.
Because I believe Kristen said we have until like April 24th, 26th, so.
26th.
Yeah, so just submit a letter to Kristen saying that you'll extend our time to
So it
act.
ends the April 26th?
Yes.
You're saying, okay.
So an
if I
additional
do
30
Through
days.
the end of May?
That's fine, yeah. That's all I have.
And then the next meeting date would be?
May 20th.
May 20th.
All right, thank you.
Thank
Um,
you.
Thank you.
So before we start the next item on the agenda, would the board like a 10-minute break? Do I need a motion for that? Or do we-
Yeah, just make a motion.
May I have a motion for 10-minute break?
Second.
All in favor? Okay,
Aye.
aye.
Could put on the record that Al and I are gonna leave and.
Yes, okay.
Yep,
Yep.
I'll say that we're acting capacity of the zoning board, Ms.
Yeah.
Wiggum and Madam Chair are not here for conflict.
Yeah,
We're
so
going-
we won't-
you guys are-
we're done, yep.
Yep, and then, Vice Chair will close the meeting up.
But I actually know this application so well, but I worked many years in
Yeah. I just recommend just like go away.
That's
good. So just say don't speak.
Emily likes your job. She got to just try to.
Just clear off.
Okay. And then
You can drive.
I mean, if you sit back and.
like this is already ongoing.
They don't.
I have to go.
Yeah, we're going.
The thing is you're going, like you're going to Lambertville, and then it's pretty busy.
Chair Emily Deadweiler has recused herself, so I'll chair the next item here. I want to call the UAW Urban Renewal Housing Corp. We're looking at Block 27.01, Lot 18.02 at 20 John Ringo's Road, Village of Ringgoes. We have an application for minor subdivision with variances and an amendment to the approved preliminary site plan. Is that right?
Correct. My name is Robin Wright. I'm an attorney from Lanza & Flemington, and I represent East Amwell, UAW, Urban Renewal Housing Corp., and WPR, WPR UAW, Urban Renewal Housing Corp. East Amwell, UAW is here for an amendment to the preliminary site plan approval that was granted last year for a 24-unit, 100% affordable senior housing building on 20 John Ringo Road. There's some modifications to the plan, primarily with respect to the driveway, and our engineer, Eric Rootnarain, is going to explain that, as well as all the other proposed modifications to the site plan. We're also here on behalf of WPR, UAW, Urban Renewal Housing Corp., which is the owner of the property. One of the conditions of the approval for the preliminary site plan with variances was that we come back before the board for subdivision. So we're complying with that condition of approval by coming back before the board. We're seeking to subdivide a part of the property that has an existing structure on it, and we're seeking certain C variances, including for lot area, lot depth, I think front yard, and impervious coverage. And we'll have Eric Rootnarain describe the conditions of the property that necessitate those variances. We also have Mark Comroe here from the applicant. He'll answer any questions you have of the applicant. And we also have Frank Banish to explain the planning rationale for the variances.
Thank you. Should we swear in?
Yeah, I'll swear everyone in. And just for the record too, our committee representative and our mayor is not here, but we're acting in our capacity as a zoning board. So that's why we only have 5 up here. And also Ms. Wiggum has also recused herself too. So just for the record, we'll also swear in any witnesses that you have right now, Ms. Wright. But while we get started,
Eric,
we can do it all at once.
Dan, or Mark, and Frank. Okay.
Okay. Can you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. Go ahead, Ms. Wright.
Eric, could you introduce yourself and explain your background as a professional engineer?
Certainly. My name is Eric Rootnarain. I'm a licensed professional engineer in the states of New Jersey and Pennsylvania. I've been licensed in New Jersey since 2003, I believe. I've appeared in front of this board and many other boards throughout New Jersey.
Is the board to accept Mr. Rootnarain as an expert in engineering?
Yes. We have, yeah.
Yes.
So approved.
Thank you.
Eric, could you, you prepared the initial site plan that was approved last year, correct?
Correct.
And could you just briefly describe the plan that you had approved, that you had prepared, and the proposed changes to the site plan?
Certainly. So last year, when we appeared before the board for site plan approval, we were dealing with a 24-unit age-restricted development. Essentially, the building that's shown on here
And what are we referring to, for the record?
That's, Eric, is that the site plan that was submitted?
Okay.
Correct.
What page?
Sheet number 5.
Sheet 5. Okay, thank you.
Should we mark that, or since it's already part of the?
We can mark it just so it's clear. So
Okay. Page 5 of the site
you
plan?
will call it A1.
A1, okay.
Yep.
I'm sorry, this is exhibit just for the board?
Yeah, just for the resolution.
Could we bring closer?
Oh.
I appreciate that.
It's also for home.
Oops, can you?
Thank you.
I might have a copy of it too,
Um,
actually.
So what I've got is the same sheet that the board has within their plan set. And this shows the modification that we've made to the site plan. The original design that was approved by the board last year, the driveway accessing the 24 units was coming in on the southerly side of the property. The property currently has frontage on John Ringo's Road on the easterly side. Originally, what we were doing is creating a new two-way driveway on this southerly portion of the property in towards the back of the site. And that driveway was providing access and parking and access to the loading zone and dumpster on the property. And the dumpster, the loading zone, they were both located on the southerly side of the proposed building. Essentially in that area. What we have done since the approval that the board granted, we took a second look at the property to see if we could reconfigure this to address some of the concerns that we heard at the meeting. Even though the board originally approved the application, the applicant was willing to reconsider to see if we could try to accommodate some of the community questions relative to having the driveway closer to the residential dwelling that's located on the southerly property. And also, if we could also move the dumpster to try to minimize any noise and so forth that might emanate from this property that could potentially disturb any of the neighboring property owners. So what we did was to take a look at the property. We knew we had to come back to the board for site plan approval, for minor subdivision approval, as a condition of the original approval that was granted. So in looking at the property and how we could reconfigure the site, the applicant undertook the expense of retesting the property to see if we could essentially build a septic system for the 24 unit, which is the larger rectangle that's shown towards the middle of the property, whether or not we could actually acquire additional testing that would be acceptable to build a septic system. Originally, we were a little hesitant to actually disturb the existing septic for the two-family house that presently exists on the property. Since the applicant took possession of the property, that house has been unoccupied. So we had the ability to go in and complete additional testing to verify that the soils are acceptable. So over the past year, we actually went back and we did the additional testing on this property. And likewise, we did additional testing to see if we could, as part of the subdivision, can we build a septic system for the two-family house, independent of the 24 units? So what we have done is, the smaller rectangle towards the front of the property, that's where the septic system for the existing two-family house will go. So we were able to meet all of those environmental requirements that the applicant has in order to subdivide the property. In addition to that, what we have done with the project right now is show how the subdivision is going to be configured. A couple of the constraints that we have in terms of the septic systems that have to be built, the state regulations require that septic systems on individual realty improvements have to be separated by at least 50 feet. So that's one of the criteria that starts to establish where the applicant can actually place the property line. In addition to that, the septic system has to be at least 10 feet off the property line. Those are some of the geometric constraints that we have in trying to figure out how can we actually subdivide this property, albeit with variances that would be necessary. How close can we get to conformity with all of the regulations that governs the project? And what we have here is a subdivision that's been prepared. And this is also one of the minor subdivision plan that's in the board set. And what we've done is to show the overall track and where the subdivision or the new lot line will be. And to the east of the existing dwelling, this is approximately where the new lot line is going to be created. And by virtue of that subdivision, the lot that the existing two-family home will be on, that'll be approximately 0.59 acres, where the zoning ordinance requires a minimum of 1 acre. In addition to that, the lot that the 24 units will be on, that will also be reduced in acreage. The original parent tract was about 6.9 acres. That's going to be reduced to approximately 6.2, 6.3 acres. The subdivision does not create any variance for the 24 unit building. All of the setback requirements, all of the bulk standards that govern that project remains. However, the subdivision does create a minimum lot variance for the two-family dwelling. There's also an existing non-conforming front yard setback that's associated with the two-family dwelling. And in addition to that, the reconfiguration of the property line also creates the need for a lot coverage variance. Currently, in order to provide access to the 24 units, the driveway access has to come in off of John Ringo's Road. And that access creates the driveway on the for the 24 units. The driveway is going to be located on the new lot for the two-family dwelling. And in addition to that, part of the parking area for the 24 unit will also be located on the two-family, on the lot that's going to be created for the two-family dwelling. The current ordinance criterion requires a maximum of 30% lot coverage. The reconfiguration that we have creates a lot coverage for the new two-family dwelling of approximately 34% will be the lot coverage. And that's the third variance, that's being created as a result of the subdivision. Aside from that, the changes that the applicant made to the original site plan relocated the dumpster area and the loading zone, which were located on the southerly part of the property. It relocated those two areas to the north, which would be adjacent to the firehouse. In addition to that, we're also showing as a part of what we anticipate being required for this development is where the underground storage tank is going to be located. And the oval highlighting, the oval shaded area towards the back of the property in that northeasterly corner, that represents where we believe the underground water tank has to go in order for us to install a sprinkler system, which is going to be required for the 24 unit. In addition to that, the applicant is also proposing to utilize a generator to operate certain basic functions within the 24 unit building. And the generator location is also shown towards the rear and into that northeast corner of the property. Aside from that, all of the original stormwater management system remains the same. There were minor modifications to the grading that's associated with the detention basin. The bioretention basin remains. It's still a green infrastructure that NJDEP recognizes. The application is still fully conforming in terms of peak rate reductions, water quality treatment, groundwater recharge. We're meeting all of those criteria. And essentially, that is the modification to the site plan and the subdivision the applicant is proposing.
Eric, is that page 6 of your site plan?
I believe you were talking about the minor subdivision plan, so we would mark that as A2. I think we were just on, right?
I just want to make sure I have the right page.
Yeah.
The marking is A2.
And that was sheet, I'm sorry, 6?
Which sheet?
3A.
3A, okay.
3A, okay,
So
thank you.
sheet 3A is A2. All right, so Eric, just to clarify the difference between the two applications, the amendment to the site plan is that we're changing the driveway from the southerly side to the northerly side, correct?
Correct.
And we are, to some degree, modifying the design and size of the stormwater management facility?
Yes.
Okay, and the proposed 24-unit building has rotated a little bit and moved closer to County Road 579, correct?
Correct. The building has been, the original building was at somewhat of an angle, and it followed the wetlands, the transition area towards the back. By shifting the building to the north, we were able to make the building closer to parallel with John Ringo's Road.
And you've also moved the proposed dumpster, correct?
Correct.
And you've added a generator pad to the back of the building.
Yes.
And you're also adding an underground water storage tank.
Correct.
And a supply well, okay. And then we're proposing a septic system for the older building on the new lot to be subdivided, correct?
Correct.
Okay. I just want to review some comments from the board engineer's memo. The board engineer says that you should revise the stormwater management drainage calculations. Are you willing to do that as a condition of approval?
Yes, we are.
Okay. And he's also wants you to confirm that you'll comply with the Title Recordation Act and the township's ordinance on monuments.
Yes, we will.
Okay, and he's also wanted some confirmation of some of the conditions of the prior approval, the emergency access to the adjacent firehouse parking lot. Can you address that?
Certainly. So the original approval that was granted by the board was preliminary site plan approval. The applicant is currently in the process of completing the necessary documentation, one of which, for instance, is the well testing report. We're in the process of getting proposals so we could move that process forward. In addition to that, we've designed a septic system which will be submitted to NJDEP shortly. That's another one of those preliminary items that we need to address before the applicant can come back to the board for final approval. All of the conditions in the original resolution, the applicant will deal with as a part of any plan revisions when we come back to the board for final.
And what is the status of the well testing?
Again, regarding the well testing, I know we have secured proposals from a few hydrogeologists. The applicant has been in contact with the board's hydrogeologists, so we could figure out exactly how to proceed forward with the well testing. The ordinance in East Amwell Township doesn't address this type of development, so we have been working with the township hydrogeologist, their consultant, to figure out how we should go about testing the well in order to provide adequate water supply to this site.
And we've provided an updated letter of interpretation for the wetlands, correct? Or
Cor-
extension from the previous owner?
Correct. The applicant has received an extension from NJDEP. The original wetland that's shown on this parcel currently, the boundaries have not changed. NJDEP has extended the original LOI for another 5 years.
And the final plan will show the location of the electrical vehicle charging stations, correct?
Correct.
Okay. And we've requested a written report from the fire department, correct?
Correct.
And we will also comply that the project will not use external leaders for rain gutters, correct?
Correct.
And what about the approvals for the 2,000 gallon per day septic system?
So the design has been completed. We're in the process of preparing the application for NJDEP submission. So that will be completed shortly.
And there are certain proposed modifications to the plans that were in the engineer's letter. Are you able to make the modifications that were proposed?
Yes, we can.
Okay, and there's no issues with respect to that?
Correct.
And we'll obtain outside agency approvals that are required, correct?
Correct.
And the subdivision plan is going to require certain easements because the rear building will cross over the new property, correct? Can you address that?
Correct. So what we have done, since access to the rear building or the rear parking lot is going to be taken through the new lot that's being created for the two-family, the applicant is proposing to create an access easement across the new lot for the two-family dwelling. And that access easement will allow ingress and egress for the 24 units. That would be for residents, visitors, trash removal, loading and unloading, and any other types of maintenance or equipment that may be necessary to move towards the rear property.
Is there anything else that you think should be addressed with respect to the amended preliminary site plan approval?
No, I believe the changes that we've highlighted completes what we have done as part of the site plan amendment.
And there's nothing else that we're addressing with respect to that? And what about with respect to the subdivision? The variances are based on the existing conditions, and correct?
Correct. Part of the approval, which requires us to construct septic systems, again, the geometries that we have and the separation distances for septic systems starts to establish where the property line can be located. Because we've got certain separations. So for instance, a septic system has to be within 15 feet of the test, the ends of a septic system. The bed cannot be any closer than 10 feet to a property line. Likewise, the septic field has to be at least, within East Amwell Township, has to be at least 25 feet from a public road, from the right-of-way line. And those are all the various geometries, given the limited space that we have between the wetland area to the back and the actual public road, to create the subdivision. Even though it's a fairly large tract, it's about 6.9 acres, the vast majority of it is encumbered by wetlands and transition areas to the rear, which the applicant, really, we cannot use it for anything.
Okay. Do you have anything else, Ted?
I have a question, just one. Are the two additional units in the old house, are they also going to be low income?
Yes.
They're also, okay. So we're going to get 26 low
Yes,
income.
the plan is to have that as affordable housing.
What kind of fuel is being used for the generator, and where is that fuel being stored?
So we have not yet completed the design, but I would anticipate natural gas.
And where's the natural gas coming from?
Presently, there is natural gas in John Ringo's Road.
Okay. And the water table for the well, how is this going to affect your, I was reading something about it should be enough for maximum usage at time frames, but how's this going to affect the rest of the neighborhood?
So that's part of the testing that we have to go through, which the applicant has committed to completing and submitting to the board, but we haven't yet done that. That's the process that we're in right now, and the original approval, which is why we sought only preliminary approval, is just given the nature of this project, the cost associated with completing that full well testing, which was adding up to, if I remember correctly, somewhere between $80,000 to $100,000 between having the wells installed, having the testing completed, and the funding source that the applicant is seeking in order to build the development. That's why we sought the approvals the way we did, by separating it out, so that if the applicant is successful in obtaining the necessary funding, all of those testing requirements, not only for this site, but any monitoring of the off-site wells as may be necessary to determine any potential impacts that this project will have on those wells, will be documented as part of the well testing report and submitted to the board.
Thank you.
Was septic the wastewater treatment solution that was always envisioned for this project?
Correct. We don't have, East Amwell Township doesn't have any public sewer systems.
I thought there's never talk about like a package treatment plant.
So essentially, what we're going to be proposing is an advanced wastewater treatment system, which discharges the groundwater. So it's not, I guess, it wouldn't be your typical package system that could discharge the surface water. It is going to be an advanced wastewater treatment system, similar to a HOOT system, but this particular project, we're using biomicrobics. Those are aerobic systems, but they're designed for basically higher strength waste. They can treat larger volumes, which this development will generate.
And there'll be somebody for maintenance for these systems when they are in place, if they do go in place.
Correct. So part of the requirement that the applicant is going to have to undertake with any of the advanced treatment systems, there's going to be a deed restriction that's going to require the applicant to maintain a maintenance agreement with the manufacturer. So there's always going to be a mechanism to make sure the systems are functioning.
Other board questions? Yes.
Eric, the emergency access to the firehouse, what is the status of that?
So-
I mean, is that, go ahead.
We agreed to provide an emergency connection between the firehouse and our property. And where we essentially envision that connection is at approximately this area. It will be shown on the final site plan.
All right, so they still need something directly from their parking lot?
Correct.
To this, okay,
Correct.
thank you.
Questions from the planner?
Nothing for the
We can
engineer,
open
thank
up
you.
to the public.
Okay, can I get a motion to open to the public?
So moved.
A second?
Second?
All in favor?
Aye.
All right, we're open for this witness to take questions from the public. Any questions? Going once, twice?
So,
All right, close to the public. All right, very good.
Sorry.
Thank you.
Next witness is Mark Comroe. Mark, could you describe your position with the applicant with Region 9?
Sure. I am the Director of Development for Region 9 Housing Corporation.
And you testified here in the past in connection with the preliminary site plan approval.
Yes.
And both applicants are connected to Region 9, correct? Both the owner of the property and East Amwell,
It's a related entity, correct?
related nonprofit entities.
Yes,
And the plan is for that 24-unit building to be affordable senior housing, correct?
correct.
And then there's a two-family house on the other parcel?
It's an existing two-family house that will also be affordable housing as well.
And you're going to renovate the house?
Yes.
Correct? And you're trying to get funding for that?
Yes,
And you're going to comply with the resolution requires you to try to maintain existing standards to the extent possible, and you still intend to do that, correct?
absolutely.
And there's going to be, who's going to manage the affordable housing on the two-family houses, a separate nonprofit entity?
Our management company is Region 9 Housing Corporation. So we will have a part-time site manager at the 24 units that will also be responsible for the two-unit house.
Okay, and that'll be affordable housing for families, correct?
It will be affordable housing for families.
And there's also a shed on the site, correct?
Correct.
And you're leaving it there, but if the board wants you to remove it, then you remove it, correct?
Correct.
Okay. You're familiar with the resolution that was adopted by the board in connection with the preliminary site plan approval, correct?
Yes.
And you still intend to comply with all the conditions of that resolution, correct?
Yes.
Okay. I have no further questions.
Can I ask the board professionals have any questions for this witness?
No question.
Just one. Do you anticipate that modifications to the existing home will need to be made to make the home ADA accessible, or is that uncertain at this time?
We're still working on all the layouts that go along with it, whether it be, for bathrooms and everything else with it.
Questions from the board?
I have a question. I don't know if this is for you or not, but where do the number of units come from, the 24 come from? And I know there's new laws in New Jersey now that the municipalities can determine the present perspective fair housing obligation. So where does the 24 actually come from?
So when we originally were looking to construct the 24 units, the funding source that we were looking at has 25 units and below is for this funding source. So we looked at 24 units of affordable senior housing. We also got a consent order that we worked on with the municipal's attorney to be able to have that in place, and they got it approved through the court and the judge that those 24 units can be applied against your fourth round obligation if you so, if you wanted to be.
And the two-family house in front, that is not for seniors, that's for
That would be for
low-income families.
Correct. That, there's no consent order yet on that. That East Amwell will have to, work, especially with the fourth round obligation, in terms of getting that credit applied against the fourth round obligation that you'll have.
Thank you.
Other questions for this witness?
Nope.
Okay, thank you.
You can
Oh,
open it to the
let's
public.
open to the public then. Yeah, thank you. My
Motion.
apologies.
Motion.
Could I have a motion to open to the public?
Motion.
Second?
Second.
Okay.
All right, getting tired here, apologies. All in favor? We all, all
Aye.
right. Okay,
Mr.
thank
Wolf,
you.
can I ask you
Absolutely.
to state your name and be sworn in since we have a new application?
Richard Wolf.
Thank you.
21 Runyearson Road here in East Amwell.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Thank you. But by the way, if you're tired now, wait till you get to be my age. You'll see.
You're a youngster.
We're way past my bedtime. Mr. Comro, is it true that you are subdividing because you have to get the grant to do the work to renovate this existing house into 2 affordable housing units?
That is correct.
So if you had your druthers, you wouldn't be doing the subdivision, you're just doing it so you can get the money to do this?
Correct.
Okay. Let me know if anything I'm saying is wrong, because I just want to get my arms, I want to make sure that the board understands this. But the world is changing in states that are densely populated, California, New York, New Jersey, affordable housing is a very big issue now. It all started years ago when certain municipalities would zone basically to ensure that their residents were only high-income residents. And the New Jersey Supreme Court said, you can't do that. That violates constitutional rights. You can't basically put up a zoning wall around your community and only allow high-income residents. That was called the Mount Laurel case. Affordable housing in New Jersey has become even more difficult since that time. And right now, there are bills in New Jersey trying to address affordable housing, one of which would actually override local zoning ordinances and allow 2 houses on single-family lots. That's how bad affordable housing is getting. We here in East Amwell have an obligation for 88 additional affordable housing units. This project will give us 24 plus the 226. Do I think that Fair Share, the organization that oversees this, believes that East Amwell is going to do 88? No. We don't have jobs here in East Amwell. We don't have water. We don't have storage. We don't have public transportation. But there is an expectation that we will provide our fair share of affordable housing. There are 2 ways we could do that. One is this sort of project, where you fit a significant number of units into a small space. I like to call that sort of the vertical, okay? Then there's the horizontal. The horizontal is a developer could come in and buy a 100-acre farm, and as long as 20% of the houses that the developer proposes to build are affordable, the developer could do a development that the developer couldn't otherwise do. So you could have 100 houses just to get 20 affordable. That ain't good. It's not good for East Amwell. It's not good for our farmland. It's not good for our school. Sooner or later, we have to have our own police department. Taxes would go up. It's not good. So my view is these sorts of projects, what I call the vertical projects, are ideal for this community. When I was at a prior hearing on this, a resident in the back said, pretty loudly, I don't want those people in East Amwell. That was the comment. My response to that is, you ain't keeping those people out of East Amwell. The law has progressed beyond that. And by the way, I want those people in East Amwell. I want people in East Amwell who are trying to make a better life for themselves, a better life for their family, a better life for their kids. They tend to be model citizens, model residents. So I'm willing to embrace those people. And you're not going to be able to close those people out. So we should be supporting, my view, this development. We should be supporting the 2 additional affordable housing. And quite frankly, if he wanted to do another 20 unit, I would support that too, as long as it's vertical. As long as you're not going horizontal. Because it's our way of providing affordable housing and not losing the rural nature of this community. And if you think that can't happen, Google Far Hills, New Jersey, and look what's happening there. Look at what's happening at Far Hills. It can get really ugly. You can't turn your back on your affordable housing obligation. Those days are gone. Why did you pick East Amwell?
For the same reason everybody here picked to live in East Amwell. I think it's a fantastic community, fantastic people in terms of that live here. We think especially the location we had chosen, the amenities, especially for seniors, of having a library across the street, having a post office across the street, having the Link bus stop right across the street, having the municipal complex 2 blocks down, having some restaurants, a bank, amenities. It's incredible. And that's one of the reasons, or majority of the reasons that we had chosen East Amwell for it.
But you did a study, correct?
We also did a study in terms of the amount of seniors, you know, the 62 and up, had household seniors that we thought was high. And we thought it's a perfect opportunity to be able to get a location to be able to have for senior housing.
So, look, the bottom line is the day of reckoning has come for all communities to provide their fair share of affordable housing. I don't think we're there yet. We should take every opportunity that we can to provide additional affordable housing, especially when it's not eating up our farms, it's not going to take away from the rural nature. The 24 units isn't going to impact our school unless people 62 years of age and older start. I mean, parents are getting older every year, but it's, you know, they're not going to have children in those units. This is a good thing for East Amwell, and I hope everybody just keeps that in mind and thinking about it. Thank you.
Thank you, Mr. Wolf. Yes, Chair recognizes Nancy Cunningham. Swear Nancy in.
Yeah.
There you go.
Ms. Cunningham, can I swear you in too?
Hi, Nancy Cunningham, 14 Worksville Road.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
I just wanted to comment, 14 Wirtsville Road is just a few houses up the street, and our property actually backs up to the Region 9 property, just actually a few feet behind our garage, actually, so it's very close to us. But, and we're very, very supportive of affordable housing, and we're also, East Amwell has since the beginning of when they put in requirements for numbers of affordable houses in communities, have always met our minimum requirement for affordable housing every year, unlike probably the majority of communities throughout the state of New Jersey. So I think this is a perfect project to help us meet the new obligations, and I think they'll be great neighbors for us, and I would encourage you to support the subdivisions.
Thank you, Nancy.
Thank you. Other comments from the public or questions for this witness? Going once. All right. Motion to close to the public.
So moved.
Second.
Second.
All in favor?
Aye.
All right. Close to the public. Thank you.
Thanks. I have one more witness,
Okay.
Frank Banish. Frank, could you review, I know you've been here many times, but can you just quickly review your qualifications as a planner?
I've been a licensed professional planner since 1975, president of Banish Associates. I wrote several of your master plans and farmland preservation plans and things like that during the time that I served as a consultant to East Amwell Township. I also do a lot of work as a court-appointed Mount Laurel master, where I advise the court on whether or not towns have met their affordable housing obligation. As Nancy mentioned, you have been on the right side of the law in part because the rules that apply to affordable housing allow you to get an adjustment to your obligation if you don't have water and sewer. So you've gotten a durational adjustment in the past and may well be eligible for one again in the future. What I like so much about this project is pretty much everything Mark said. There's almost nothing. I'll say a few things because I have to for the variance purposes, but the truth is everything about this is really good, and without this opportunity where the Fair Share Housing Center has made it clear that you will get credit for these 24 units in the fourth round, or at least that you'll have the right to apply for that credit and nobody should deny it to you. Now it's going to be 26 units. 2 of those are family units. Family units are the most prized because they're the ones that are hardest to find, and family rentals are the most valuable low and moderate income housing other than special needs units. So what you're getting now is a combination. let's say the subdivision is now allowing you to sweeten the pot with those additional 2 units, and the fact that they're family units, I think, is highly desirable. You should feel good about being able to do that. And the fact that they're willing, rather than just selling the building to somebody to redevelop for market rate units, that they're adding those 2 additional affordable units. The variances that are required for this subdivision include the lot area, which is a little more than half an acre where an acre is required. The lot depth, which is almost 120 feet, but 150 feet is required. And lot coverage is 33, and I think slightly more with the sidewalk that we've just added, at 34%, where 30% is permitted. These are conditions that we're creating by putting the subdivision line into the property, meaning I can't claim that there's a hardship because of that. I could tell you all the things that Eric said about how a septic system determines where those lines go is very meaningful, but I think really the criteria for this variance comes under NJSA 40:55C2, 40:55D-70C2. And the C2 variance is the variance that doesn't need to demonstrate that there's a hardship, that allows you to make a finding that the purposes of the statute, that is the municipal land use law, would be advanced if you granted the variance, and that the benefits of that granting of the variance far outweigh any potential detriment. And so I'll cite for you some of those statutory purposes that I think are clearly supported here. First one is purpose A, to encourage municipal action to guide the appropriate use of development, all targeted toward the general welfare. So the general welfare is being advanced by creating this housing opportunity in the center of town. Subsection E is to promote the establishment of appropriate population densities that will contribute to the well-being of persons, neighborhoods, and communities. I believe that that's exactly what you're doing by putting this well-designed, well-located project in a walk-to-town location where seniors couldn't ask for anything better in Hunterdon County, really. Unless you're in the middle of the county seat, you're not gonna really have the chance to just get out and have everything that close to you and be in a nice village setting like this. Subsection G says to provide sufficient space in appropriate locations for a variety of uses, including residential uses, and specifically senior housing, low-income housing is important residential use. Purpose I seeks to promote a desirable visual environment through creative development techniques and good civic design and arrangements. And I believe that creating the small lot that will allow this house, this 2-family house, to be funded and to continue to exist and to look very much like it's looked for more than 100 years is a signature element in Ringo's that rather than being lost to a project like this, which so many times happens, is actually being saved by a project like this. So the conservation of historic sites and districts, which is subsection I, the statute seeks specifically to do that, to save things like this that are deemed important, and we're doing that. And one of the purposes, in fact, the only purpose in the land use law that has a specific use that it targets is encouraging senior citizen community housing construction, which you argued when the variance was initially granted was one of the main reasons why you should support this. The other part of the test relates to whether or not there are benefits that outweigh the detriments. And here, I don't see any discernible detriments, really. There's a neighborhood full of relatively small lots, many smaller than the ones that were created up and down the block from us. And it's an in-town character. As you get out of town, the lots get larger, but we're right in town. And I would suggest that while there are no detrimental effects, the subdivision does promote the general welfare because it enables that conservation of the historic site and provides for long-term protection of an historic dwelling. It also enables the subdivision, enables the saving of the dwelling as an adjunct to providing the supportable housing, as I said a minute ago, kind of doubly beneficial and sweetening the pot with those 2 other units. It's also consistent with the small lot pattern in the historic village center. I pulled up the tax maps and made a point of looking at all the lots in the middle of town, and anybody who would do that will see that many of the lots are smaller, substantially smaller than a half acre. And it enables the retention of an attractive historic dwelling that contributes what I think, and I think you probably would agree, when it's fixed up will be a desirable visual character in the village that's kind of a signature element in what the place has always been. I think in all the years I've been driving, I live in Delaware Township and I have since 1976. So I've been driving through Ringo's almost every day since 1970. And when I think of the buildings that have always made an impression on me, the John Ringo Homestead building was one you can't forget, but this building, just because of its detailing and its positioning in the village, it's just prominent. It's one of those things that kind of makes you smile when you go by, so hopefully we'll make you smile even more in the future. With regard to the negative criteria, there will be no substantial detriment to the public good, which in fact will be advanced by allowing this new construction of affordable housing and this rehabilitation of an historic dwelling. And the zone plan will not see any substantial detriment because the subdivision we're creating will not be out of character with the downtown and will enable the financing of these affordable housing units that we've just described to you. So I would submit that you are well within your rights to grant the variances that have been requested and that the public good will be substantially advanced when you do that. Thank you.
Ms. Wright, just as a matter of procedure, do you offer Mr. Banish as an expert in planning?
Yes, I do.
Thank you.
Accepted.
And does the board accept Mr. Banish as an expect in planning?
Yeah.
Thank you.
Accepted.
Thank you. I
Thank
went to
you.
school to be an architect. It's good.
Thank you.
Can
Frank,
I-
there's a new, the state just passed a new affordable housing law, correct?
Yes,
And the fourth round starts in July 2025, is that correct?
it does. That's the end of the third round, beginning of the fourth round.
And this certainly makes the town look proactive in terms of addressing its affordable housing needs, correct?
Yes, and the new legislation really has taken a much more urgent tone. For instance, there are certain regulations requiring that within 48 hours of the time that you adopt a certain resolution, you have to alert the Department of Community Affairs to that. So they're trying to put the towns in a much tighter box. The earliest estimate we've seen says that you're probably gonna, the formula that the legislation provides for will probably require this fourth round that you would produce about 87, 88 affordable units. I suspect you're gonna end up again with another durational adjustment unless somebody comes to town with a sewer plant. So projects like this are gonna be about the best way that you're gonna find to bring affordable housing into town and hopefully into the kind of settings like this where it makes the most sense.
Thanks, I don't have any further questions, Mr. Banish.
Okay.
You're getting, let me say this, when we first came in with this, I don't think anybody had a sense that affordable housing rules were gonna get flipped on their head the way they have, and that the Council on Affordable Housing would be thrown out the window, and that you can lose immunity under this new system pretty easily compared to the old rules where you got immunity and you pretty much could count on having it for some period of time. So I think taking proactive steps like this right now are a really smart move for a town that may not be able to do a whole lot else than relatively small projects with on-site systems. Thank you. I'll shut up now.
Thank you, Mr. Banish. I'd like to ask if the board professionals have any questions for this witness. Okay. I'll open to the board for questions.
You know, on the last point that you just made, if you allow me, I think that if you do not provide affordable housing, the fines are enormous from the state. Is that true?
Well, the biggest risk that you run is that if you are non-compliant with the rule, with the requirements for an affordable housing plan that meets your need, that a builder then can come in, buy, let's say, option a piece of property, figure out that it's the kind of property where the soils would actually allow an on-site system to do some serious provision of sewer. And you might see, you won't see hundreds and hundreds of units on that kind of a system, but you might well see somebody come in that with the right farmland could build 100 or more units with an on-site system, out of which you would get 20 affordables, but as your former mayor said a couple of minutes ago, when those 20 affordables come with the other 80 market rate units, schools have an impact, the roads have there's all kinds of different impacts compared to a nice tight project in the middle of town like this.
Thank you.
Thank you.
Other board questions? Want to open, can I get a motion to open to the public for this witness? Second?
Second.
Okay. All in favor? All right, we're open to the public for this witness. All right, gonna close, going once, twice, all right, we're closed. All right. Do you have other witnesses?
I have no other witnesses.
Okay. It is 9:35. I'm mindful of the time here.
let's see if our professionals have any comments.
Okay.
And then we'll leave it up to Ms. Wright.
Okay.
Nothing particular to add. I think that all the points that were raised about the upcoming fourth round of affordable housing obligations and the work that this project is doing to that end, and certainly as what we consider an infill development within the center of the village, is beneficial. And the board's already found that in its previous approval, and the subdivision was essentially a request, a condition that was placed on that approval. So I see nothing to raise any concerns from a planning perspective about this application.
Okay.
Yeah, I see the testimony of Eric tonight that all the requirements of the previous resolution will be addressed, the plans will be updated, so I think that'll be good for the board to see that when they come in for final.
So,
We'll leave it to Ms. Wright to,
I would just ask the board to vote to approve the amendment to the site plan and to vote to approve the subdivision and the 4 variances that we asked for.
and one last thing there, caution, let's ask for public comment on the entire application.
so with that, I'd like to ask for a motion to open to public comment.
Motion,
Second.
public comment.
A lot of motions tonight.
And all in favor? Okay, so we're open for public comment for a motion to approve, on a motion to approve the amendment to the site plan.
Yeah, so this is just general public comment.
General
if
public
anyone
comment.
wants to talk about, not about just one witness in particular.
No? Going once, twice. All right. Closing
Okay.
to the public again. All right.
Okay, so does the board have any questions? If Ms. Wright seems like she's concluded her application for tonight, we have a quick summary of what's being asked in the application, and then the board can put up the application to a vote. So I'll just give a quick summary of what was presented. So as we all know, As we all know, we are here for 20 John Ringos Road. This application was already approved by a use variance for the actual use. So while we are talking a lot about affordable housing and number of units, the use was actually approved back last year. So all we have before us tonight is the minor subdivision and the amended site plan and the bulk variances associated with them. So we have a 24-unit age-restricted housing structure that was previously approved, and the subdivision tonight was also part of that approval, where the applicant was required to come back and seek approval for the subdivision to subdivide off the existing 2-family structure, which will also be affordable housing. So again, the applicant seeks amended preliminary site plan approval, minor subdivision approval with some bulk variances to subdivide the 2-family structure into a new lot separate and apart from the 24-unit structure. There are several things that were different that the applicant discussed for the amended preliminary site plan. Relocation of the driveway, modified design and size of some stormwater facilities. The structure and the parking has been moved a bit. Relocation of the dumpster, addition of the generator, addition of the underground water storage tank, and addition of the proposed septic for the 2-family structure. The subdivision, correct me if I'm wrong on the acreage, but the new parcel will be 0.59 acres that's being created by the subdivision, which leaves about 6.3 acres of the existing lot. Lot 18.01, which is the existing lot, will contain the 24-unit structure, and the proposed lot 18.02 would include the existing 2-family dwelling. There are 4 bulk variances that we have tonight that the applicant has testified to: minimum front yard setback, minimum lot area, minimum lot depth, and maximum lot coverage. The applicant also discussed an easement for parking and access. So for our standards to approve this application, so for amended preliminary site plan, the board must determine whether the proposed development conforms to the township zoning and the site plan ordinance, subject to any waivers and variances. So the board is really here to make sure that the application is compliant, subject to any variances and waivers. regarding the bulk variances, as Mr. Banish testified, we're here for a C2 variance, right? So for the positive criteria, we have to talk about all the purposes of zoning that Mr. Banish went through, that there are several, and then whether those whether they are beneficial, and that outweighs the detriment. And we also have to think about the negative criteria. Negative criteria, which Mr. Banish also went through, is whether it would be substantially detrimental to the public good and substantially detrimental to the zone plan. So with all of that said, last thing with any waivers, whether it's just feasible or would create a hardship when it comes to waivers. So with all of that said, it's up to the board to make a motion on the application.
So moved.
To
approve.
Let's be clear about what we're approving
Yeah.
here.
To approve the amended preliminary site plan
Yes.
with the bulk variances and the minor subdivision.
Yes.
Okay.
Do you have a second?
Second it.
Okay. All in favor?
Let's do a voice
Oh,
vote.
sorry,
Let's
voice
do a
vote, okay.
vote, yeah.
Great, okay.
Could I get who seconded that again? Mr. McGovern, thank you. All right. Mr. Kadri,
Yes.
Mr. Catenacci,
Yes.
Mr. McGovern,
Yes.
Ms. Teresi,
Yes.
and Vice Chair Kohut.
Yes.
So the motion
Ivan.
carries, the application's approved, thank you.
Thank you.
Where's Francis?
She missed a big one.
Is there a motion to, do you need a motion to?
Yeah, we
adjourn?
do. Yeah, we can't leave, but they all.
Yeah.
We still have some business, I believe.
While
Sorry,
they're,
professional. I
Thank you.
think Emily wanted to come back for the last of the business, right?
yes.
We have some business left to do. Mr. Catanacci, you made the motion, right? And then Mr. McGovern, you seconded.
Oh, there you are. I was just texting.
I was watching out.
Oh, okay, all right.
Oh, sorry.
I know everyone will start getting up and everyone doesn't get to leave just yet. Not quite yet. We'll make it quick. We're all here.
And they address every concern, and we have, especially the public is. I need arborvitae, and then in the next meeting, I change my mind, I don't want
No,
arborvitae.
we
I want- and they, whatever you need.
I was at the meeting last year when it was the first introduction. The conceptual.
Yeah.
It just, the conceptual, and the place was packed.
Oh, yeah.
And
And there are a lot of people, and Rick was right, there are a lot of people who were, you know, pull up the ladder people. We know them so well.
I guess sometimes people are afraid of.
Continuing on.
Not even.
I think, you hear me?
Some people just.
We will.
Don't wanna.
Okay. Next up, new business. We have none,
No.
unless you want to add something.
Say that.
I'm missing part of, oh, here we go. And then, so invoices for approval. Everyone had a chance to have a look?
Yep.
Okay. May I have a motion?
I so move that we approve these invoices.
Second? Can I have a second?
Second.
All in favor? Okay, invoices approved. Next up, items for discussion. There are none. Oral reports. Ms. Wiggum?
We're continuing to work on the 3 initiatives that we have to build community and work with other committees to deal with unfit and unsafe houses. We're waiting for a report, a written report from the building inspector, construction inspector. and to deal with the circulation plan. We're waiting for a meeting with the state. We also are looking at, when you come off 202, what the speed limit is, how it goes 45 down to 40. And one of the things that we're hoping comes up in the meeting is that it's 35 all the way through the village, and that we don't go through this blah, blah, blah. Because it's pretty heavily residential at the beginning. The other thing that we talked about were pests and vectors in the village, and working with the health board potentially on that.
Okay. It sounds like you have an active committee.
We do.
Yeah, that's good. Mr. Kadri, FOSPA, I never can say that.
Our last meeting was canceled. We do have the draft farmland preservation
recall that,
plan. And so I guess the next thing to do is to collect comments. I have a question about that. What's the most efficient way to sort of save the township money? Do you, like, I have some questions, but I don't want to burn up hours answering them until we collect everybody else's input and maybe, you know, give the professionals a clean copy.
Mm-hmm.
So just, and this is speaking purely in generalities, it's always most efficient for us if we get one set of comments.
Right.
So however you want to handle that through a committee or through, through the board.
We'll try to do that.
Because it avoids duplication, and it also just can help streamline the back and forth process.
Because you haven't seen this yet, right? I think it goes to the ag committee, like there's a whole public process yet.
I bet
So
you that woman right there knows.
We'll have to solicit,
We'll get to her in a minute.
We'll have to solicit those comments, and I guess I'll ask my colleagues or maybe volunteer to do that.
Yeah. So
And
you're
it's just like it's anything else, you always want to hand in the best version of your paper that you can hand in,
Yeah.
right? So
Right.
if you have the ability, like, to give a kind of compile everything that you have questions about, it's easier for the professionals in their review to streamline it more efficiently.
Okay. With the Environment Commission, I went last week to this live training that NJIC held for environmental commissions. It was really good. They had people who were struggling with like the warehouse issue.
Oh.
And all of this kind of, here's their warehouse brochure. All of this information and examples from other municipalities that are doing what we're doing. So I collected that. That was useful. There is a proposal next week to potentially combine the Environmental Commission and the Recycling Committee. So we're gonna figure out what that might look like.
Okay.
And see if we can't get some efficiencies. There's a number of people that are on both.
Okay. Just timing, I guess.
Yeah.
Jim, what was the organization that you went to the
It's-
conference about?
I think it's the Association of New Jersey Environmental Commission. Here, I'll send you some of their stuff.
Give it up.
Yeah, I mean, they've got a staff of folks that are putting all that information
Just
together.
knowing that resource is there and we can read it and,
Yeah.
Yeah, no, it's good to know. At least in the minutes, we can reflect where he went, so we can always go back and find
It was in Somerville.
Yeah.
They hosted.
I meant the name of this, not where you
Oh,
went.
right,
We
yeah.
we actually wanted your GPS mapping. I'm
Yeah.
just kidding. It's getting late at night, I'm
They
sorry.
did have, they had a municipality that did all of their kind of environmental resources on a GIS platform that Princeton Hydro did for them. That was interesting.
Reddington.
Yes, yeah.
Really, really good.
That it?
That's it.
Okay. Just as an FYI for Historic Preservation Committee, so we're still working on filling out these. Mary Van Horn will be joining us, and rumor has it she is also on that committee, so we're hoping that she will become our official liaison. I think Kristen may have discussed it with her already. Yeah. And then, one thing, Kristen, anything from you?
No, just when you see anything confirming attendance, please respond as soon as possible.
Yep. And then I have just two quick things. One is, maybe this may have gotten lost in your emails, and I want to make sure you all saw it. I asked Kristen to send out the planning board bylaws so that you can read them and know the rules. I found them helpful when I sometimes go to them, like, what are the rules for how late we can take testimony? Things of that nature. So they're there, and I just thought you should all know that they exist and can read them. And the other, yes.
It's hard, I don't like to read on computers, I like to read on paper. Can we get a paper copy? It's a lot of pages.
You can at any time ask Kristen to print out something for you, and just give her the only thing I ask is don't everyone call her the day before a planning board meeting and ask her to print them all out.
Friday afternoon.
Friday afternoon, it's the same as Friday afternoon. But, and I don't think you would do that, Candace. So, yeah, you can ask her to print these things out for you.
Okay.
Yep. And likewise, when I first joined the board, I was sent a tutorial. It was official. It was some background information that I thought was really helpful that I also forwarded along. Something I was given when I joined, so I forwarded it along. And then there was one other thing. Oh, and then now that we've gotten things hopefully a little bit in order, we've got our different applications moving. We've got our board filled out, our professionals hired for the most part. We will also start I want to turn back to the master plan and that long list of things that we had to do. Particularly, I think the last one that we discussed was the ordinance committee. I think myself and Al Nardi were on that. If there's anyone else who wants to volunteer, but here we will bring that back up and we'll start hearing about, go through that long list. I think that long list is still in the drive. Is it correct, Kristen? The master plan priorities list?
So we have been sharing monthly, so it.
Oh, you don't load. You have to load it every month. Okay.
Yes.
I will ask.
But we can compile the drive so that everything's accessible through one link. If you would prefer it, I just tried to keep the complication. Like I tried to keep it. This is what's in front of us.
Yeah.
So it's up to you on how you would like that.
Well, there's some
presented.
things that continuously you want to access at all times, like the bylaws and the master plan. Perhaps there's something. Let's see if we can keep it
Isn't it on the
thinking.
website?
It is not, because it was a working document. But let's see how we can maybe make it simple. Would you guys prefer to have one link that you always go to, no matter what, and then you just have to navigate to the meeting?
That sounds great to me.
Okay.
Yeah,
Okay. So
that's
we'll work on doing that.
Yeah.
And it was really important we spent time on that. No, I'm just kidding. No, I think it's important that we make it easier for you to find information, know where to get information. If you need something printed out, please ask. If you don't want paper, you don't have to have any. So, okay. And with that, open to the public. May I have a motion to the large group of people out there? Thank you, Mr.
Motion to
Katanachis. May I have a
adjourn?
second?
Not yet.
No, not yet. Second?
Yes.
All in favor, open to the public? Anyone have anything to say out there? Aye. May I have a close to the public? May I have a motion to adjourn?
Second.
All in favor?
Aye.
Good night.
Aye.
Thank you.
Good night.
I don't want to go.
I know you don't.
Oh.
I gotta take it. I gotta take it to the homework. To just do fair. Good job.